maybe participated the land matter not for tribunal. Because one tribunal matter is permitted mention for listing the matter for
New matter. New
no,
matter.
no, old matter.
Hearing.
Hearing.
Which year?
2022.
My lord, may I have your lordship can leave to mention, my lord, one matter, my lord, I want to file it without certified copy, my lord.
Was the order passed?
Order passed, my lord, August 2024.
Obtain the certified copy.
My lord, I have
Did you
applied.
apply?
I got the, my lord, the present advocate got the information on Sunday. On Monday, he applied. Lord, he prepared, and we have not the. We shall move it with the certified copy,
What
with the
is
server copy.
urgency, sir?
Urgency is this: on Sunday, the block land and land reforms officer came to the land and trying to demarcate. Not the my business will be.
Obtain the certified copy and
I have
file.
already applied, but
8 months ago order was passed.
it is true. But not the this
No,
not
no,
the.
this indulgence cannot be
But
given,
can
sir. There is no
No,
such urgency.
I only not the.
Obtain the certified copy.
But I shall file the
Lordship,
application. I shall only not. I want.
No, no, this is becoming a practice.
What?
New advocate engaged, 1 year gone, now give me leave to file without certified.
Shop room will be demolished. Not only this is the problem. Not I shall file it. Not I shall already applied on 15 on 13, my lord. On 13, my lord. I only pray for, my lord, without certified copy, my lord. I have annexed them, my lord.
যত flaws সেগুলি থেকে যাচ্ছে।
But I have annexed the, my lord, the plain my lord, the server copy of the order. Kindly, my lord, grant me leave to file this.
Leave granted, yes.
Grateful to your lordship, lord.
My lord, I am mentioning an application for restoration upon notice, my lord.
Yes. Yes.
May I have the liberty to mention this matter? Yesterday, the matter was, my lord, taken up for consideration contempt. 36. That your lordship directed the matter to appear on 25th of February. My client retired, my lord, in the end of March. So, my lord, the direction was, my lord, directed.
Vasu, it cannot be taken up in the meantime because my brother won't be here. Circuit benches we have to go.
But
Because it is a contempt, I cannot take it up with any other.
No, before 25th, my lord, any day, my lord, subject to if my lord justice.
No,
physically, I mean, I shall serve personally, my lord.
I am returning after circuit on 24th.
Oh.
This is the problem. That is why we kept it on 20.
May I have your
আমাদের circuit
may permit to mention.
কবে থেকে করে? 10 থেকে?
Because if I can serve them, my lord, by tomorrow or Monday, if that is.
No, 25th, yes. Right, because we would be returning then
Your Lord,
on 20.
Lordship, may I permit to mention a restoration application upon notice?
Yes. Yes, what you
But may be permitted to mention one contempt application. I have mentioned twice, my lord. Yes, my lord. My lord have allowed such application, but am I mentioning?
fresh note,
But the file is missing. The FMA filing is missing. I was told the FMA file.
contempt, fresh
Yes, my lord.
contempt.
Yes, fresh contempt. The FMA file is missing. I have also wrote a letter to the registered also. My lord,
FMA সাথে আসে নাকি?
6-10 পেজ
না, তো এমনি কন্টেম্পটা লিস্ট করা যাবে না?
my lord, if my lord so
যদি দরকার হয় এটা
একটু দেখে নাও যদি আসল রিকুইজিশন। You have to inform our officer where the file is lying. If the file is not there, you will have to take steps.
My lord,
My officer cannot reconstruct.
No, my lord, I have taken all the steps, but I have also.
You have to go to the department, tell them the fact. If the FMA is found, it's a fresh contempt, it will immediately be listed. But
It's a
without
fresh
the
contempt.
file, we cannot include. My officer cannot help you.
My lord, I understand, my lord. The
So you
contempt
take-
file is here, but the FMA file is missing. The
And
fresh
the contempt file has
Yes.
to be along with the FMA,
Yes,
na?
my lord. That is the difficulty, my lord.
Let us see. তুমি একটু ফাইলটা সাহেবকে দেখিয়ে দিতে পারো। Yes.
Your Lordship, may I mention a matter? This is a restoration application I have filed for restoration of the writ petition.
Are you mentioning upon notice?
Yes, Your Lordship.
Yes, take it. Yes.
Kindly release this matter before 23rd so that the hearing can be.
That cannot be assured, madam. Let us see what can.
May I have your lordships kindly to mention a matter for inclusion, my lord. What has happened? My lord had released this matter on the ground that a similar judgment was passed by a division bench.
I do not understand. You give both sides, give consent before us. When it goes to the other bench, which will
We did not.
you
The other,
take a different
the other side took a different stand. We did not take a different stand. That is the problem.
unfortunate. No, you should have told that. It was said-
I had specifically told my lord honorable justice Shen that
similar matter decide করেছে, please ওই বেঞ্চে গেলে হলো।
when it goes to the other bench, the other side says that it is not a similar matter. What
This is
can?
the practice, unfortunate practice generating, what can we say?
But if it can be included, my lord, in your lordship's list.
এটা, কি হয়েছিল জানো, ওটা বলেছিল।
ফাইলটা বার করে দেখতে হবে, তাহলে আমরা নোট নিয়েছি।
রিলিজ করেছে, দেখেছি আমি ওটা। It was when it appeared before us. What is was it in the supplementary list?
My lord.
What is the urgency? You are the appellant.
I am not the appellant, but I have a contempt petition pending, and they are stating that this is the appeal is pending. So
But
no,
appeal, there is no interim order.
there is no. But the contempt court is adjourning the matter for that. For
That
which,
is for you to explain the contempt court.
but if it can, if
explain
it
the
can be
entire scenario, explain the entire scenario. We cannot assure you immediate enlistment because we
but
don't know where is the file, whether it has
that
come
that
down from-
I'll have to take. I'll take steps in accordance with
দেখে
that
নিও, যদি পেয়ে যাও তাহলে দিয়ে দেবো।
deeply.
My lord, I am mentioning a service matter for.
Please mention upon notice, madam. Give a notice to your other side and mention. Yes, call the list.
My lord. My lord, I may be permitted to mention matters, my lord. Item number 20 to 23 of today's list, my lord. I know there is no required to mention, my lord, but there is extreme urgency, my lord. That's why I'm mentioning. My lord, kindly take this
All the
matter
matters were called yesterday. 20 to 23.
My lord.
Yes, it will be taken up, madam. Please wait for the call. Yes.
Wait for your.
What correction? What correction?
ও জানে না,
My lord's
মানে
pleasure was to dispose of the matter on 8th of January.
দুটো ক্যানি 25 হবে।
একটা আমাদের
25 হবে। By reason of a typographical error,
so many applications. But
It was taken up by your lordship on the other day. Milord, one is Milord can 6 is restoration, can 7 is Milord section 5. And others are all Milord substitution, setting aside abatement.
Oh.
The matter of 2002 and original proceedings of 74.
can 6 or 7 কোথায়? রেখে দাও এসে। How many days delay?
My lord, 1 year.
Huh?
1 year.
What is the main matter about?
Milord, what happened? A proceedings was initiated, Milord, in terms of the Milord West Bengal, Milord restoration of alienated lands, Milord, for declaring a land that it was a distress sale. Now, Milord, that was allowed. Challenging that, my learned friend's client, Milord, had went to Milord for a revision before the subdivisional land reforms officer. Milord, that was held, Milord, as not maintainable, and from there we have preferred an appeal court, Milord, affirmed the Milord order of the Milord the revisional court. Now, Milord, from there, Milord, we went to the Milord land tribunal. Milord, land tribunal, there was a we have also, Milord, lost before the land tribunal. Then, Milord, this Milord.
So what is the present state of affairs?
My
There
lord,
was a deduction for distress sale.
distresses, my lord, before till Milord dismissal of this matter for default, all throughout this court has passed an interim order that was Milord pending. Rule was issued, Milord, that was pending. Milord, therefore there was no, as such, there's nothing has happened. Interim order was subsisting all throughout. Now, Milord, due to the dismiss for default, Milord, this has, Milord.
My lord, I am for the respondent number on 5 only, my lord, because no other came forward, my lord. Regarding, my lord, restoration, my lord, kindly come to page 19 of the petition, my lord, paragraph 14, my lord.
You are 5.
Yes. Porimol, my lord.
You paragraph 14 of what? The
Of the
restoration?
restoration application, my lord.
There is no paragraph 14 in 5.
4.
4.
Mhm. Page 19. Page 19.
Yes.
My lord, entire allegation against the advocate, my lord. But no disclosure, name of the, no step has been taken, my lord.
Not at all. Well, it is not that, Milord. Kindly see subsequent paragraphs are there. He was conducting, Milord. He has expired. I have also, Milord, given the death
Can
certificate.
6 and can 7. Can 6 of 2024, can 7 of 2024. So, as the other
Yes, next.
Item number 3.
I'm waiting for the respondent, my lord.
But I appear on behalf of the petitioners. But there are two applications, one for restoration, my lord, one for seeking condonation of delay. My lord, the erstwhile learned advocate, my lord, he was old and ailing. My lord, the matter was dismissed, my lord. He could not inform the clients. After dismissal, my lord, we have obtained no objection, my lord. The client has obtained no objection. And thereafter, my lord, the application is filed. There is a delay of about 850 days.
Long delay.
But this relates to, my lord, the renewal of a lease under the 2002 mining rules. Lord, my substantive right, my lord, to seek a renewal is contained in the contract. This relates to my right to livelihood, my lord. Delay may not stand in the way, subject to what my learned friend says. My application paragraph 9 to 12 explains, my lord.
So your writ petition was for inaction towards consideration of your
Only consideration,
application for
only
mining
consideration.
lease,
Yes, and the learned trial judge has, my lord, observed
because
that-
you did not deposit the fees.
yes, my lord, I have, my lord, document signifying that the fees has been paid.
Show us.
Yes,
Then
But-
why didn't you show it to the writ court?
my lord, kindly, my lord, takes my supplementary affidavit. I have pleaded, my lord, that I have sent. The challan was not annexed. My lord, I sought leave, but that was declined. I have, my lord, affirmed a
Where
supplement.
it was declined. A court does not record any such
Yes,
finding.
but kindly sees, my lord, the document, my lord, the document.
Show us from the writ petition that you made that statement of deposit.
Yes, yes. My lord, it is there, my lord. Kindly sees. Yeah, ये तो देखो. My lord, kindly come to page
Now,
87.
who is in possession? The question of possession doesn't
Doesn't say
appear.
this
It's a
one.
mining lease.
It is not, and there has not been any fresh grant in respect of this land as yet.
To apply afresh, Mr. Chaturvedi.
My lord, the question, my lord, today
You
is
will be facing another hurdle of amendment of the rules also.
no. My
That
lord,
has been repealed.
Reciprocity.
my lord, that is what, my lord, this honorable court, my lord, has held. My lord, that in so far as
Why you're insisting on that, Mr. Chaturvedi? We will dispose it of giving you liberty to file afresh.
my lord, it is as and when, my lord, the auction takes place. Number one. Number two, my lord, I may not, my lord.
This is a long-term lease.
Yes.
It has to be through auction now.
No, my lord, subject to my rights, my lord, which are reserved under the earlier agreement. My lord, I am entitled to extension of, my lord, at least.
Mr. Chaturvedi, that is
My lord, I am, my lord, fortified by a division bench judgment of our court, my lord.
judgment pertaining to what?
My lord, the rights, my lord, conferred under the agreement, under the contract, which, my lord, reserve the right, my lord, for an extension that cannot be, my lord, taken away by a prospective amendment. My lord,
Your
61 and
application, you preferred the read saying consider my application.
yes.
Show us that application of yours.
My lord, kindly
Where
come
have
to
you
page
taken any
87.
ground to that effect?
87
87.
of my writ petition.
'87 is Form D under the old rules.
Yes, yes. My lord, kindly sees. This is, my lord, under this forum, the application is required to be made. Kindly see, my lord, the postal receipt. This was annexed. What was not, my lord, annexed
This
was
is not, this does not contain your signature also. Page 87.
Milord, in the original, Milord,
Simply a form has been annexed.
Milord, a form has been annexed with the postal receipt. Milord, kindly sees, Milord, the challan was not annexed. Milord, the challan are contained here, for which, Milord, I have affirmed a supplementary affidavit. Kindly sees this.
You
Milord,
check up, Mr. Chu, you check up when is the challan, when was the deposit made?
yes, Milord, same day, 29th August. আরেকটা দিয়ে দাও। It is on the same day, Milord.
এটা তো চাইনি, ফুলগুলিতে কনসিডার।
Where is the renewal clause of
Yes.
their agreement?
Yes. Lord, kindly but the agreement, Milord, starts at page 11 and the renewal clause, Milord, is at page 48 of my stay application,
48.
my lord. Today, Milord, my writ petition is dismissed solely on the ground that I have not deposited. Now that the deposit challan, Milord, is available, let the respondents consider my, Milord, application. I shall go and make representation citing the law decided by this honorable court that notwithstanding the 2016 rules coming into force, my application is required to be considered in terms of the old rules. Let them decide that. As of now, my application has not been decided by the authorities. And the learned trial judge,
Your application was 31st August 2016.
yes,
And your
challan is 29th August. I need to first deposit and then, Milord, make the application.
So
with,
where have you stated in your application that deposit was made? Show us that line.
That
Because
was
it
not
was
annexed
on
to the writ petition.
31st August.
That was not annexed to the writ petition, the challan.
31st August was your representation.
my lord,
You deposited on 29th August.
Milord, 29th August is the challan and 31st is the application in Form D.
Show us that this application in form must have a column towards deposit of the amount.
Paragraph 11 in my stay application, paragraph 11.
Milord, kindly comes to paragraph 11 of my stay application.
No,
that is
kindly come. Your page 87, where is your application, Mr.
Milord, this application is in a particular format, which is at page 87. This is Form D.
You will not keep a Xerox copy of the same. Form D is available. It is an unfilled application.
Milord, it is
You are asking us to believe that, then show us any
Milord, this
forwarded the long-term lease
Next place.
on it to hand it over there for renewal upon compliance. In your representation made to the authority also, you did not state that I deposited the amount and I made the application.
Milord, kindly sees, Milord, page 89 is, Milord, my letter, which, Milord, says,
comply with formalities. So show us.
Yes.
If you had applied, Mr. There has to be a Xerox copy of the application at least.
Milord, kindly sees, Milord, this is, Milord, a form, a format. But kindly sees, Milord, from the top, this is in terms of 12:1 on the top. Now, I am to, Milord, type out this form, fill up this form and submit. All that, Milord, has not been done. Is, Milord, the signature. In my copy, I have not, Milord, signed. And before it was filed in the annex to the writ petition, Milord, it should have been signed and then annexed. That is, Milord, only my lord, latch which, my lord, in my understanding, I have committed.
Read
But
court
kindly,
will-
I'm sorry.
Read court will accept this dispute. You are not even
No, no, no.
fortified with a
No, kindly see the postal, I
31st,
see it,
31st August was your representation of 2016,
my lord.
and you issue a demand notice after so many months, 21st February 2017. So you were admittedly waiting for that period. You have not explained the delay in making the representation.
My lord, only my lord considers
Mr.
that my
Devi, we
application,
will give you leave to apply whenever when the auction is made. You participate.
my
in
lord,
that auction.
kindly, my lord, considers this.
Yes.
My lord, kindly, my lord, takes up, my lord, rule 12, the old rule 12. What am I, my lord, supposed to do?
Old rule এখানে নেই। You give the old book,
Yes, yes.
2002.
Repealed in
Lord, I cannot.
এখন তো রিপিল হয়ে গেছে 16 রিপিলের পরে অ্যাপ্লিকেশন করে বলছে আমি আগে টাকা জমা দিয়েছি আর এখানেও ডিলে আছে কন্ট্রাক্ট
followed rule. Which rule you are showing, Mr.
Lord, kindly sees 12.1. 12.1, I'm sorry.
Months before the date on which when was your lease expiring?
Lord, my lease was granted on 2nd March 2012 and was, my lord, expiring on 1st March 2017.
5 years lease.
5 years, please.
long-term five.
And, my lord, I cannot make an application, my lord, anytime before 9 months and not, my lord, prior to 6 months of the expiry. So it is in between
For 9 months of what?
the expiry I cannot make. That is 12.1.
At least 6 months before the loan or due to expire, not before 9th month.
From the date of
Yeah.
Very good.
So before 9 months, I could not have made.
Your application was 31st August 2016,
Yes.
and it expired on
My lord, 1st March 20.
12.
No, it is expiring in 2017. 1st March 2017.
Yes, and you made it on
31st,
August 2016.
my lord.
Very good. Then
So I could not have, my lord, made before this time. And I could not have, my lord, made any time more than 6 months. There has to be an application at least 6 months prior to my expiry. So I have, my lord, fulfilled this criteria. Next is that I am to deposit 500 rupees. I am showing to my lord that I have deposited this, my lord, 500 rupees. Today the question is whether the state exchequer has received this 500 rupees within this span of 9 months and 6 months or not. If yes, and if there is an application which is pending, I am saying that it is to be decided in accordance with law.
application lost its force, new rules came. Repeal clause does not save any pending
My lord, that-
imperfect application.
My lord, then, my lord, that is, my lord, what, my lord, I was, my lord, respectfully submitting that our courts, my lord, have decided that, my lord, in so far as the rights, my lord, yes.
Anything done, any action taken, or any prosecution started.
আরে আরেকটা
No action started.
দুটো কপি দিয়ে আপনি কি করছো?
Difference দেবে? Difference আছে?
নতুন হতে যায় না পুরনো।
Lord, I have only one copy today, my lord. May I come back with, because I was,
No,
No problem.
you have your copy.
no, my lord, I am giving my copy, my lord, my.
Okay,
Then-
so you read the relevant portion.
ওনাকে দাও।
Another day you read the relevant
My
paragraph.
lord, my lord. So this my lord says, the last paragraph on page 9, having heard the learned counsel for the parties, it appears indisputably the petitioner was a lessee of mining lease. The said lease was initially for 5 years. Thereafter, it was extended for 5 years, and then on 8th February 2016, the petitioner prayed for renewal of lease. On the date of submission of the prayer, the West Bengal Minor Mineral Rules 2016 did not come into force. This rule came into force from the date of publication. Thus, the said rules came into force on so and so date. Before said rule coming into force, the petitioner already took steps for renewal of the mining lease. The petitioner also directed to deposit a sum of rupees so and so on the basis of the order passed by the additional the petitioner and one Payal Chaudhary, whose case was decided in favor of by order dated 7 July 2015, were directed to obtain environmental clearances within 3 months from the date. Therefore, it is crystal clear that even the concession rules 2016 came into force. The respondent authorities acted on the application. In such view, the court is of no alter.
Acted on the application.
Acted of that.
But this is not
action started.
and Milord, other Milord decisions, Milord, they are on the issue that since there is a contract inter se between the state and the petitioner, a prospective amendment cannot take away that vested right.
Provided an action was initiated. If there is nothing, what will survive?
Milord, action initiated, the action was initiated by me.
Action.
I am one of the contracting parties to the agreement.
Maybe, but your application was defective.
Milord, this is not where Milord I join
Your
issue.
application was 31st August 2016.
Yes.
When did the new rules come? Tell us.
Milord, 29th July 2016.
So 31st August, when the application was made, there was no right subsisting for renewal of the lease.
Milord, in that event, Milord, may I, Milord, come back, Milord, on this issue? This requires to be, Milord, argued. But this requires to be argued. I have, Milord, I am before a court which, Milord, which wishes to learn.
No, that is all right. That is your, in spite of your best efforts, Mr. Chudra, we are unable to accept.
Milord, may I, Milord, only submit this. Milord, kindly seize this.
Though it is in the morning first half, we can dismiss it in the evening also if you so want.
Kindly do not express. Kindly do not express my lord's amendment. I come back on some other. Kindly restore this. I come back on some other day.
Mr. Chudra, when the new rules came into, after that your application was made for renewal, which itself was not maintainable.
Milord, I kindly, Milord, permit me, Milord, to consider.
31st August was your application.
Yes.
Rules have come prior to that.
Records I can't wish away, I can't wash away. May kindly permit me to come back, Milord, on this.
To be mentioned Monday.
Yes. Milord, kindly restore it.
On that.
We will restore and pass order up. No problem. Number কি অনেক আছে to be mentioned?
No order, no fees.
No order, no fees. That order. Mr. Chotuedi, learned advocate appearing for the appellant, files a supplementary affidavit. Stop. Let the same be kept on record. A copy of the same has been handed over to Mr. Rai, learned advocate appearing for the respondents in court today. You got it?
I have not got it.
Give a copy of the supplement.
I have sub. I've already sub.
Even the knee. Just got it. Just
The in court today. So is the matter for further consideration. Same heading এই তো থাকতে পারে না এটা restoration তো under the heading to be mentioned in the daily supplementary list of this court on আজকে 16 তারিখ তো 20 তারিখ করে দাও 20th.
I'm grateful. I'm deeply open. I could say so many things because again I say that I am before a court which wants to listen.
No.
Sorry, but I could not.
Come on Monday.
Right.
This is my application for restoration. Due to illness, I could not appear in the court. This is only ground I have taken, and this is the ground.
Mr. Paja,
Lordship.
you must be remembering one matter came up before us when you also were there. And both the parties said that yes, the other similar matter has been heard by the other bench.
Yes.
Recording your consent, we released the matter and it was placed before Justice Sen's matter. When the matter appeared before Justice Sen, his lordship was pleased to observe Mr. Paja says that this is not identical. That means we have told a lie in our order. It is not identical. This was submitted before us that in spite of that we have released. This is the most humiliating aspect which can appear. And the matter now, the other side comes and mentions and says that we were agreeable with Mr. Paja to do the matter. But it was Mr. Paja who said that it was not submitted. We are surprised to learn, Mr. Paja. This becomes an embarrassment for us, as if we are recusing ourselves from a matter. We are dealing with 1,000 matters, and we deal with the respected advocates on the basis of their submissions.
Yes, my lord. This has never happened in my life. The first time I'm hearing.
Check up, Mr. Paja. It was recorded in Justice Sen's matter. We felt so embarrassed.
Yes, I know.
We felt so embarrassed that why should an advocate say one thing before us and go and say something else to a coordinate bench? We were very shocked and sad to learn this.
And not fair on my behalf also, I must say. It's not fair on my behalf.
Today morning, today morning the matter has been mentioned.
ধনঞ্জয় ঘন্টি
ওরা আমি shopping এ
দুনিয়ার কোথায় এই এটা সম্বন্ধে একটু খোঁজ খবর কর আমাকে বল একটুখানি ভাই জজ অজের এম্বারেসিং আমার এম্বারেসিং না হয় আমি কিন্তু মামলা ছেড়ে দেবো ইটস এম্বারেসিং
Is the order there of Justice Sen? ওইটাতে আছে? Please read Justice Sen's order, Mr. Paja. Or I may read. Please give it to me. I have read it. I felt very embarrassed.
And it is embarrassing for me also.
Sure, sure. I will read it aloud for you.
I will never.
And what happened after I released, the matter was placed for assignment. Our order was noted by the Chief Justice and the matter was reassigned to the bench of Justice Sen. When it came before Justice Sen, this is the order. Mr. Paja, learned counsel appearing for the appellant, submits that the issue involved in this appeal may not be the same issues decided by the court. I don't know, because somebody else was your junior. I don't know in what circumstance. And we said, in course of hearing, we have been informed by the learned advocates appearing for the respective parties that an identical issue pertaining to the same selection process was considered by the coordinate bench presided over by Justice Sen. This was our order. This, on the basis of this order, matter was placed before Chief Justice. Chief Justice assigned the matter before the other bench, and the other bench makes this comment. And that too, at your presence, I could have understood it that you were not. We are also, Mr. Paja, we believe our advocates.
Yes.
Stray incidents may happen, but still we believe our advocates. This practice should not, because it ridicules us, not only before the Chief Justice, but also before our coordinate bench.
Let me inquire into the matter, my lord. I must say, if I find anything wrong, I will not appear henceforth. But this has never happened in my career as an advocate. This much I can say.
I am sitting here for 11 years. In 11 years also, I did not also face such humiliating situation.
Yes, I can feel it.
Yes, what is the matter?
The restoration application, only one grind.
The respondent number 1, read petitioner, my lord.
Now, my lord, on the day the matter was taken up, I was not well. I could not, only ground I have taken, because this is the only ground.
7 except one incident I remember, where a senior member came and mentioned before the matter was listed, it was a question of subsistence of an interim order. I was told I usually do not see the affidavit of service or notice which is issued by the advocate, because I believe my advocate. My advocate says served. I believed the advocate. I kept it on record and I vacated the interim order. Do you know what happened? Within 2 days, the advocate came running to the court and said, "My lord, I was never served. I kept the matter for to be mentioned, and when I asked the senior advocate, sir, why did you say this?" The senior advocate turned to his junior and said that তোমরা সব আজে বাজে জিনিস বলবে and we have to face. I said, sir, please do not blame your junior. Your junior is not to be blamed because we have learned, we have heard it from you. That was one instance I remembered, and this I felt humiliated.
If
This I
that
felt.
be so, then it's my fault. I
No,
must say.
it's not a question
No,
of
no,
fault,
it's my
Mr.
fault.
Bajaj. You are doing hundreds of matters. It may not be possible also for you to remember that what matter, what identical issue, what.
But even then, if that order is there, then it's my.
But our order was there.
No, I'm saying that it's my.
And it was
embarrassing also.
said that it was an identical. We are doing thousands of matters. Why should we not take up one matter?
Yes, yes.
We do not have anything personal in this. For the easier way for disposal. If the other bench has afresh heard a matter, issue is identical. In fact, to avoid conflicting decisions, this is done. Yes, Daku Kunman. তুমি অর্ডারটা দেখেছো? তুমি বেইজ্জত হয়ে যাবে না চিফের কাছে, কারণ আমাদের অর্ডারের বেশি চিফের কাছে। চিফের সাইন তোমায় দেখাও, ফাইলটা এখানে আছে? ফাইলটা কি এখানে আছে?
সাইন করুন।
চিফ দিস ইজ দি অর্ডার, চিফ সই করে আছে।
ওইটা লিখেন, কেন রিলিজ হয়েছে সেইটা লিখে।
কোনটা রেস্টোরেশন অ্যাপ্লিকেশন করতে?
রেজিস্ট্রেশন অ্যাপ্লিকেশন কি হলো?
আমারটা কি হলো?
There is a section 5 also.
অ্যাপ্লিকেশনটা
No, my lord, there is no section.
Appeal section 5 was allowed and appeal admitted.
Yes, appeal admitted. There was a direction for paper book, my lord. The paper book has already been submitted, my lord.
But the only difficulty is
Yes,
that
the matter was
after
actually
dismissal, we have returned the file to the government.
hearing.
কি হয়েছে? তো কি হয়েছে?
My last look at
No,
the
no,
matter.
I think
appeared
Mr.
under
Paja will
hearing,
supply
my lord.
the extra copy to us.
Hearing.
Most
Yes.
certainly not.
Ready for hearing, my lord.
আমার শরীর খারাপের জন্য আসি
What was the interim order?
My lord, the
দেখ এই বেঞ্চে রুটস অফ আর্গুমেন্ট হয়ে গেল, শুনানি হয়ে গেল। এটা কথা। আমরা এত বেশি চিন্তা করি না সেভাবে রুটস অফ মক্কেলের কি হলো। কোনো ইয়ে আছে তো? রিটেন অনেক অনেক এটা শেষ
তুমি কে?
অন্য একটা
What was the interim order?
Milord, may I say, Milord? The question was that the writ.
No, what was the interim order?
কি মনে আছে নাকি এতদিন?
চেয়েছিল না কেন? চেয়েছিল না কেন?
yes, my lord, there was an interim order, my lord.
There was no interim order.
So no requirement of reinstatement of any interim order. Only restore. Huh?
My lord, interim order was, my lord, order dated, my lord, 26 September 2020.
Yes.
My lord, there was a direction, my lord.
It was
to release
since
the
it has been
payment.
submitted by Mr. Paja that authorities are ready and willing to release the payments.
Yes, my lord.
In terms of the letter, the appellants are directed to pay such amount by 30th September. It was paid.
Yes, my lord.
Then what was the interim order? There is no.
My lord, that is the interim order during the pendency of that appeal.
Oh,
my lord, the
So
amount
the
was
question of
directed to-
restoration of any interim order does not arise.
By
Because
mistake-
pursuant to that, you have
that
deposed.
if that has already been implemented, my lord. Your lordship kindly fix a date for hearing, my lord, because it is pending, my lord, since long.
The 10/3 of 2023. 24. Yes. This is an application for restoration. Stop.
সাপ্লিমেন্টারি দেওয়ার কথা ছিল। সাপ্লিমেন্টারি
My lord, in this matter, my lord, I have been requested to pray for 1 week's adjournment on behalf of Mr. Bhaskar Manna. My lord, he has not come.
I'm for the state respondent.
We have to.
With item 6, Lord, I am for the petitioner. Lord, this requires consideration by the appeal court. The single judge was of the opinion the policy decision could not be interfered with by the writ court and the judicial review. That's the order and the challenge. The basic problem was the denial of benefit of promotion by amendment of rules. That is the basic consideration, which requires consideration by the court. It was dismissed, and that's the appeal. But court is not audible to me.
Sorry. File your paper books then.
The paper book has been filed. If your lordship kindly fixes a date, it can be heard out on merit.
We have been informed that the appeal is ready for hearing and paper books have already been filed.
I have already received, my lord.
In view thereof, list the appeal for final hearing in the combined monthly list of February 2025.
Deeply.
দিয়ে দিচ্ছি আমরা ফেব্রুয়ারি বলো না গ্রেটফুল টু
Oh, just a moment. Yes, madam. This can application we can dispose of. Can one?
Can one?
একটু can one আছে একটা?
Stay application, my lord.
So there is no scope for any interim order.
No, my lord. No, my lord.
Can you ask Mr. Bhattacharya to appear?
Yes, my lord. Then I have to go call him, my lord, once. He's not online right now.
Oh. The disposal for there is no scope for him.
There is no scope. The learned court has refused to.
You please. He does not have to join. We may not join. We will be saying that there is no scope for interim order. Achha, you ask him to join.
Yes, madam.
Pass over, madam. Please sit for 5 minutes. একটু থাকুক এখানে।
তারপরে 2023 order.
পরেরটা দাও।
6. My lord,
7 করে দিন।
my lord, on the last occasion, my lord was pleased to direct us to serve again. My lord, as per my lord's direction, my lord, we have served by speed post with the respondent who has not appeared, my lord, except 10 appeared. All of them other did not appear in spite of service. So, my lord, we served them again, and most of them except 2 are showing their service. And my lord has also directed us to serve a copy of the this application along with the forwarding letter and the order to the advocate who appeared in the trial court, my lord, in the before the single judge, my lord. That we have done, my lord. Mr. Surya Shekhar Veshu, we contacted him. I talked with him, but he has refused to accept, stating that he does not now have the authority to accept.
Then who is respondent now at 11?
11 is most probably Buddhadev Dash, who has appeared, my lord, on the last occasion, my lord. Just a minute, my lord. Yes, my lord. Buddhadev Dash, for for Buddhadev Dash, my lord, Miss.
Who is he?
She appeared, my lord. she's a practitioner of this court. She has appeared on the last.
Respondent number 11.
For 11, my lord, Miss Anita Kundu appeared, my lord, on the last occasion. She appeared in the matter.
No, why did you implead the respondent number 11?
My lord, in the trial court, there were 13 petitioners. So
No,
we have filed the
candidature of only 2 persons were directed to be reassessed.
my lord, but all of them were parties. So, my lord, in the appeal court, all of them were the petitioners. So that would be misgender of parties in the appeal. So we have added them. And my lord, one more thing, my lord, if your lordship kindly allows us, on the last occasion, it was found out that some pages of P2 annexures were not there in the copy that has been supplied to my lord. So that was filed. My lord, I am, if your lord, with your lordship leaves, I am
What
filing a
interim order you
supplementary
are
affidavit.
What interim order you are praying?
My lord, the stay of the operation of that impugned judgment passed by the learned single bench. And my lord, if your lordship kindly allows.
I will no. Upon respondent number 6, not complete.
My lord, 6-9 has not complete. I have stated that. Yes, my lord, it has not complete.
Is it
It had
complete
come
up
back
to-
with the insufficient address, but that address was there in the writ petition
So
itself.
is it complete so far as the 2 persons are concerned? Those.
Yes, my lord. Krishna Murari Kumar and Vinod Kumar. My lord, I'm checking, my lord. I'm checking, my lord. If your lordship kindly. Most probably, yes. Still, I am checking 1 second. My lord, Krishna Murari Vinod Kumar is 10, my lord, and Vinod Kumar's postal receipt is, my lord. Acharya, Police Station, Bihar. 8133 81322. 81322. Pankaj Mandal. Vinod Kumar, most probably, my lord, it is.
You check up and come, Mr. Doctor.
My lord.
And give a notice to this Anita Kundu also so that we can.
My lord, and in the meantime, if your lordship kindly allows us to file a supplementary affidavit, because some of the pages
We
are
will
missing.
take it on record on the next day. We are keeping it on Tuesday.
My lord.
Yes. He has appeared.
My lord, he's a bit unwell, my lord. I communicated him. He's a bit unwell, my lord.
No.
That
Whether
is the
there
reason.
is any scope.
No, my lord. There
public-
is no scope
So
for
we
interim order. It can be fixed for final hearing, my lord.
Yes.
No,
So
we
we
will-
can dispose of the stay application.
Yes, my lord. Yes, my lord.
Item number 6.
Item number 6.
Pass.
Dismiss হচ্ছে promotion ইয়েটা. You have challenged the eligibility criteria fixed by the
Yes,
employer at the time of giving promotion.
Promotion.
The matter has been dismissed.
Dismissed.
Court refused to interfere.
Interfere.
Promotional process completed.
No, my lord. The promotional process has not been completed. The examination is, my lord, still pending, my lord. We are now exempted to appear.
All
in the
right,
promotional
as it is,
criteria.
it will remain. Same, that order will remain. Yes.
Obliged.
It will appear along with the application order.
In the monthly list of February, my lord.
Yes, next.
8, my lord. I am for the appellant petitioner, my lord. I have served everybody, but I not been affirmed. Actually, every service not been affirmed.
Not this week. Yes. Yes, 9.
Your Lordship, I'm appearing on behalf of the appellant.
Hmm?
Your Lordship, my senior is trying to log in. My senior is trying to log in. Urmila Chakraborty.
Who is your other side?
Your Lordship, we have given them. We have served them.
Where is your senior? So when he will come? Why he is appearing online? He's not
your-
here in court?
Your Lordship, she is in some other court. She is trying to come.
She's trying to in any
Please,
other?
yes, Your Lordship.
Not today. Yes, next. Yes,
Item number
10.
10, my lord. I am for the writ petitioner, the respondent number 1.
Who is for the appellant?
My lord, I beg to appear on behalf of the Miller.
The earlier learned advocate on record told me that the copy had been served, but no documents with me.
Copy served upon whom?
Upon the state and upon the private respondent.
আমি তো আছি, আমি তো অ্যাপিয়ার করছি স্টেট হয়ে।
He's for the state, you are for Dhruvo.
In case, my lord, I am for the writ petitioner, my lord.
Writ petitioner
Is respondent
number
one. Yes, my lord.
Mr. Dey is appearing for state.
Yes, ma'am.
Then this Gram Panchayat is necessary.
No, my lord.
Tell us what
Nobody
is
is
the
necessary,
matter.
my lord. It is the 10, my lord, the order is passed under section 10 of the.
Let us hear him, Mr.
No, only for, as your lordship, my lord, desired to ask him to whether panchayat is necessary or not.
Oh,
I
achha, not
submit before
necessary.
your lordship, panchayat is not a necessary.
Yes,
party.
yes. Yes, Mr. Dol.
Yes. My lord, page 38 is the impugned order, my lord, under challenge. My lord, only one point is involved in this appeal, my lord, whether the writ petitioner have any locus standi to file the writ petition or not. His right is not infringed and the mandamus not to be issued on the basis of the writ petition filed by the writ petitioner.
My lord, may I indicate?
Yeah, just. So this inspection has been done now.
Yes, on the lordship, the BLRO has completed the demarcation process. The assistant in
presence, was he present?
Yes, lordship. On all were present.
All were.
All were present. The assistant engineer PWD has already issued notice for hearing. This is the copy I'm handing over.
He is the adjoining owner.
No.
Then
that is why I raised this point.
So you tell us what is your case.
My lord, he is the Gram Panchayat member. My lord, one light post, iron pillar going to erect in front of my building. That is why I raised objection and one writ petition was filed by me. And the Honorable High Court directed, yes, you removed it. On the counter blast, the complaint was lodged by the Gram Panchayat member who residing at least 2 kilometers away from my house. And my lord, the writ petition was filed. The maintainability point was raised. How his personal grievances is created and how his right is infringed. My lord, and kindly have a look into, my lord, page 33, my lord, what was his complaint. Not only kindly have a look into last two lines. আশা করি আমার অস্থায়ী ব্যবসা ও এলাকার জনসাধারণের সুবিধার্থে যাহাতে উপরে উল্লিখিত বেআইনি গৃহ ও বেআইনি ব্যবসার বিরুদ্ধে আইনানুগ ব্যবস্থা নেওয়ার জন্য আবেদন করিতেছি। Then he should go to the public interest litigation.
How can we help you, Mr. Dolopati? Now the order has been implemented.
Not Miller.
Yes, the inspection has been conducted and it has been sent to everybody. You have participated in
Miller, the
that.
notice was served upon me also
So you
for
have
inquiry, and I raised the objection there. And Miller, if your lordship adjourn it, tomorrow I will place that. Now it is not.
This is a allegation is you are occupying public land. This is the allegation against you. Now on that basis, if a public land is occupied, then that has to be removed in accordance with law. Even if you have to be thrown out, they have to follow the process of law. They are following the process of law. At whose instance it was done, it is at this present moment. Locus, even if it carries weight, direction has already been passed, inspection has already been conducted. At this stage, how can we stop the other portion of the order?
Milord, what's happened, Milord? I am telling your lordship very honestly, Milord. Earlier, this question was raised and inspection was done at the behest of the direction of the court below, and that document is not annexed by my learned advocate with this, Milord. And the plot is disputed one, and I am not on the public land. I am residing on my own land. And Milord, the documents, earlier the matter was adjudicated. Kindly allow me, I will file all those documents by supplementary affidavit.
That is the merit as to whether you have encroached or not. It is the assistant engineer concerned, BLRO will consider that. Now the court has given a certain direction that has been acted on. Now at this stage you are raising the plea of locus standi, that the petitioner who has no connection with your land has filed with it. It is yours. So at this stage, whether this point can be interpreted or not.
Milord, the
order already acted upon.
Milord, the appeal was filed within time, Milord, and they hurriedly,
By passage of time,
my lord, hurriedly they issued notice, and nothing was executed, Milord, on the basis of the order passed by the single bench. And till today, Milord, only notice was served.
No, inspection was done.
Inspector, I have received
hearing under the purview of the according all appeared in the aforesaid hearing on the scheduled date. What
Yes,
is
my lord.
the date?
Scheduled date is my lord 21st of January.
21st
of January, my lord.
This is by the assistant
engineer. Yes, my lord. Before that, there was a direction upon the
conduct an inspection.
Yes, my lord.
Where do we find that? That was done.
Yes, my lord. That was done. I have been told that report is not with me, my lord, but that has been done. That has been completed.
For my instruction is, my lord.
And my lord kindly comes to my lord.
Of this January, the hearing to be made.
He is to send one representative.
Where is the order influence? Order influence page?
Page 38, Milord.
It's 38.
Lord, 7th November order was passed.
My lord kindly comes to page 40 in the last paragraph once.
Jurisdiction assistant engineer. 8% completed. Now assistant engineer now given a hearing. Or in the event.
Yes, my lord. In that
BLRO has conducted an hearing. BLRO inspected the plot.
BLRO inspected the plot.
Can you show us anything?
No, my lord. That report has not been handed over to us. BLRO report.
When was the inspection?
That inspection, my lord, has already been done. That particular date, I am not aware, my lord, at this point. But BLRO has already done. BLRO has already sent his report to the assistant engineer. Only then the notice was issued, my lord. in the spirit of that particular impugned order. That has been done. And my lord, even the issue of maintainability, that has also been decided before the learned single judge.
Public land kotha. Equation is public land. যে লোকটা মামলা দিয়ে তার কোনো লিগাল রাইট কি হয় সে কোন
Regular jurisdiction of this court has been.
What will be
Our order.
Yes, Mr. Day, you have received that instruction, BLRO?
I have not received any instruction. My lord, according to, if the notice is, my lord, if your lordship 40, page 40 months. Second paragraph. In view of the above, the jurisdictional block land and land reforms officer upon priority.
That is what we are wanting to know.
Yes.
Has it been done?
Yes, my lord, that otherwise, my lord, I am coming. My lord, I am going to the, and the private respondent shall cause a physical inspection of the alleged encroachment and construction and shall submit the report before the petitioner, private respondent and the jurisdiction engineer.
That they have not received.
Now,
I'll file a report. He will conduct an inspection and give a report to them.
Yes, my lord. That report has still not yet come, but we have received the notice.
Notice is this notice?
Yes, my lord. We have received the notice.
The court has said that you have to submit
then,
the
my lord,
report.
we must give all the parties, give them copies to that
No, why should you?
report of the BLRO. Order is that BLRO, without giving them report, one person. Order is that BLRO will conduct a physical inquiry. And if
In the presence of both the parties, it is the admitted position, my lord. Both the parties were present at the time that was done. But only, my lord, that the submit of report, private respondent, and that part was not there. But the assistant engineer took, my lord, received the BLRO report and my lord issued notice.
Where do we find that BLRO report was received?
My lord,
এই তোদেরকে দিয়েছে report?
Report এখনো আমার হাতে আছে।
তুমি my lord কি control you bring
My
the
lord, assistant engineer interested.
BL and LRO report.
You show us that the inspection was held in their presence. Finished.
Yes, my lord, I can, your lordship can fix one date, any date.
21st is the date fixed for hearing of the matter before the assistant engineer.
That is Tuesday.
Tuesday.
Tuesday, I think today is.
We want to see a written
My
instruction.
lord, I must time my level best, my lord, 21 Monday.
21 is Tuesday.
Tuesday. My lord, in the meantime, I can. My lord, your lordship fix the matter Monday.
Also, hard Mr. Affidavit of service as file be kept on record. Hard Mr. Dolopati, learned advocate appearing for the appellant. What is your name, sir?
Mr. Nilabho Bera.
And Mr. Bera, learned advocate appearing for the writ petitioner stroke respondent number 1. Mr. De, learned senior advocate appearing for the state respondent.
Mondir Bajar.
Is directed to avail necessary instruction. বলে দিয়েছো। Verification to be. Stop. Stop. It is important. Needs to that.
রিপোর্ট তো শুধু দেখে শুনতে পারি এই পোর্শনটা হয়ে গেছে পরের পোর্শনে
whether any pursuant to the court's order, any inspection was conducted like that.
কন্ট্রাক্ট হয়েছে যদি কন্ট্রাক্ট হয় তাহলে ইয়েটা পাঠ আছে এই জায়গাটা দেখা
না এটা তো পরের বসে গেছে আগে কথাটা প্যারা 3 তে এটা তো হচ্ছে অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ারের কর্তব্য। আগে কথাটা
If the inquiry will show some allegations,
in view thereof, এটা একটা part। আর পরেরটা
এইবার
আমাদের তো এইটা দেখতে হবে।
এবার এইটা যদি হয় তখন এইটাকে পারমিশন দেওয়া
হ্যাঁ, এটার জন্য রিপোর্টটা তো দেয়নি, আমরা এখানে
দেওয়া উচিত ছিল।
কি লিখেছো? মিস্টার দে লার্নেড সিনিয়র অ্যাডভোকেট অ্যাপিয়ারিং ফর দি স্টেট রেসপন্ডেন্ট।
Allow me, not in this issue, my lord.
Bring those copies, whatever
Yes,
copy you have.
Lord, what's happened, my lord? The locus standi should be decided by your lordship. Why?
Show us any authority.
My lord, why, my
My
lord?
lord, if your lordship will.
No, kindly allow me, my lord. I want to.
We
tell
understood
something-
your
something
point.
different thing.
We understood your point, Mr. Dolopati, but if we find that the inspection was conducted, in that case, sorry, we cannot interfere.
My lord,
And you have to pass subject to your satisfaction of the point. You are a locus standi is one when your legal right has been violated, whether constitutional right has been, but you have to remember in the backdrop of encroachment upon
Yes.
public land.
On this issue, I want to harping, my lord. My lord, so many writ petitions are filed before this court, honorable court. But why I am telling before the highest judiciary, my lord, the honorable court directed the BLRO and something else, other officials, you do inquiry, and they are inquiring the matter illegally. Litigation is increasing, and the harassment is increasing to the public.
You are
My lord, in this issue,
as a council, not as the secretary of the bar association. Yes.
in this issue, my lord, there is no PWD map, but BLRO will say definitely.
Have they asked you that you go away from this place? There are plenty of stages remaining. Let us ascertain.
Yes, ma'am.
It is not that by this order everything has been snatched away from. Yes.
My lord, sorry, my lord.
Grateful to your lordship.
Next.
I am for the writ petitioner.
Lord, I appear for the appellant in this matter.
I am appearing on the state, my lord.
Lord, I have served upon the respondents, my lord. The appellant before your lordship, my lord, is the private respondent in the writ petition. Respondent numbers 8 and 9.
Kindly see the
You obtain leave.
Leave niye chile?
This was your certified copy is here.
Leave niye chile?
Certificate copy there.
Achha.
Certified copy is there, my lord.
What is it, Mr.?
My lord, if your lordship kindly comes to the order, my lord, impugned.
Same order.
Yes, my lord. Same order, my lord. Despite service, they are not chosen not to
Lord,
appear
on
before
the-
the court. They have, sorry.
My lord, when the writ petition was taken up, my
Give
lord,
us 2 minutes.
my lord, when the writ petition was taken up,
Yeah, just one.
the
Give us 1 minute.
my lord.
Repetition. Appeal.
Name order passport. Yes, you are the person who is occupying.
Yes, he's occupying the land in front of the 2 plots belonging to the writ petitioners. But the case is that, my lord, the writ petitioners are having 2 plots. Their contention in the writ application was that in front of their plots, two, in front of their plots, my lord, two shop rooms were constructed by the private respondents, that is my client, which they are running since 1963. Since the year 1963. They want free access to the main road.
But the
That
portion
is
where
why-
your shop room is there, that is a government land.
Yes, that is a government land, my lord.
So you have been there will first there will be a demarcation, next there will be a hearing.
Yes.
All opportunity will be given to you. But
My lord-
what is the
my
wrong
lord-
with the order?
My lord,
Your
as-
right to livelihood is at stake. That will
Yes,
be
my
your
lord, that is my first argument. The right to livelihood is at stake. And the second argument, which my learned friend in the last matter submitted, that's the point of locus standi. That also, my lord, I have taken.
No, here it is
Because the writ
here it
petitioner,
he there the person is residing 2 kilometers away.
and this land, my lord, does not belong to the writ petitioner. The writ petitioner,
residing there.
no, he's not residing there.
Yes.
It is not his land. In the writ application, he has stated that is in front of his land. The land does not belong to him. Had it been
my land.
No.
Access from road. Yes. Being blocked by you.
no, after this order was passed, my lord, I've been told, my lord, the parties sat together, my lord. Yes,
I have no right.
আচ্ছা
My
বলুন
let-
না, বলুন।
Sorry.
the part.
Your client has met with you.
No.
Oh, সেই
He is not present, man. No.
not present না কোনো দুঃখ পাচ্ছে। Yeah.
My lord, after the order was passed,
Agreement regarding the PWD land.
no. Yes.
To private
But
party.
regarding the access,
That together-
they want full access to the road. So they said that give us 12 feet land through that
to you.
through where we are,
Fantastic.
and we said that we can give you 8 feet. So they did not agree.
None of you are the owners of the land.
No.
And you are deciding, all right, I will give you the, don't withdraw the
None are owners of the land, my lord.
exactly.
It is a PWD land, my lord. The point of locus, my lord, which I
Settlement
took,
has
that is only for the reason, my lord, that this is a PWD land that they have also admitted.
Any physical inspection conducted?
Yes,
My lord, I am the state appearing, my lord.
Yes.
Yes.
Please,
Physical inspection.
submit the reports, my lord, after
That is what
the
I was
order
pointing
passed
out.
by the Honorable Justice Anuruddha Roy, my lord. Inspection was made, my lord. Copy nahi.
In their presence.
Yes, my lord. They were asked to join a hearing, my lord, in the office of the Assistant Engineer, State Highway, my lord, on the concerned place, my lord. And thereafter, my lord, it is admitted position. They are running the business from 30 to 40 years at that place, my lord. The place is government land, and they are by preparing a construction, they are selling furnitures in these shops, my lord. And they were given time of 15 days to demolish those constructions. And
Where is that order?
My lord, kindly please, my lord. This is what I was.
This one.
Yes,
I
my
think that 2nd of January, my lord, 2025. My lord.
10-1 notice has been issued.
And my lord, they have given 15 days time, my lord, from the date of issuance of the notice, my lord. Assistant engineer.
10-10-3. Then you have to appeal 10-4.
My lord, actions has been taken, my lord, as per the order of the single bench, my lord.
My lord, after the appeal was filed, my lord, and it was served, my lord, they have done everything, my lord, without waiting, my
Appeal
lord.
has been filed in
Yes,
on
December.
16th of December, I think, my lord.
Yes,
as per
and this order was
agreement
passed on
date, my
2nd of January.
lord. Come down. And
Now from the assistant engineer, this will go to, this is 10-1,
Then
10-1, my
10-3.
lord.
then 10-3.
Remove. They will remove. Now
They will
ask
give a
you
notice
remove.
him to,
Now they have asked you remove.
where is that notice, 10-1 notice you have annexed?
my lord,
10-1 notice is there.
my lord, I think, my lord.
Yes. Mr. Mitra, proceed with them. Now you will get a 10-3 order, then you will can go for appeal. Those provisions are there.
My lord, kindly give us some breathing time, my lord. Within 15 days, they have asked us to demolish and clear that. My lord, if your lordship kindly,
It was the Highways Act.
last.
That if
West
you
Bengal
don't
Highways Act.
remove, then the proceedings under section 10-3 will be initiated.
Hmm.
Then they will say that now we will remove. But before such removal, we shall give an hearing. You will get hearing. And even the order passed under 10.3 is applicable under 10.4. Even you will file appeal before the district magistrate. So go on that process.
That the court has also said, that the court in its order,
My lord. Well, the court has stated regarding inspection and submission of the report, but to that, up to that stage, my lord, the court has, and that order has been passed, my lord.
10-1.
Yes.
So your statutory remedies are able to you.
Oh, it's a yes to about. Have you bought the book?
No, my lord, I'm sorry, my lord, I don't have the book with me, my lord.
Act 1964.
Gone. You have the Bible?
Where you have not brought the writ petition also. What was the statement? We don't know.
No, no,
So you should have annexed to your stay application.
I should have, my lord. My lord, I got the brief, my lord, only day before yesterday. I'm sorry, my lord. My lord, I have been briefed. My lord, this is the writ petition. My lord, may I hand it over, my lord? This is the writ petition.
File a supplementary evidence, whether we keep it on Monday, both the matters.
My lord, may I enclose this order also, my lord?
Whatever you have to enclose,
No, this
your
is the
supplementary evidence.
the 10-1.
10-1 not required, he has brought it.
Very well. My lord, I will,
Mr. Mithrul and the advocate appearing for the appellant, press for leave to file a supplementary evidence. Supplementary evidence be filed by tomorrow.
Yes.
One page supplement.
Yes, I will.
Is the matter for further consideration with copies to the learned advocates appearing for the respondents. Is the matter for further consideration under the same head, under the heading to be mentioned, the daily supplementary list of this court on 20.
Right.
On Monday it will be there. In the meantime, bring the.
In the meantime, my lord, let them not take any steps, my lord.
15 days.
15 days to 17th.
Huh?
Second, from 15 days, 17th, my lord, tomorrow.
No, they
15
will
days
not
they
remove. When they will issue the notice under section 10.3.
10.3.
That you have
Thereafter 10.4 the remedy is there.
despite this opportunity given to you, we have not removed. Now we shall remove. But before such removal, you are giving notice and an opportunity of hearing.
10-3 stage has to go.
Yes.
Or
Yes,
we
ma'am.
can pass orders here and now. We will give you, you will be able to avail the statutory remedies available.
That will be better, my Your lordship kindly passes that on. Kindly
Where
passes.
is the book? Highways Act? It's Come, file this supplementary. Come on Monday, let us. Yes.
My lord, one indulgence, my lord. One indulgence, my lord.
Service করতে হবে।
এক সেকেন্ড হ্যাঁ স্যার সোমবারটা আমার একটু প্রবলেম আছে তো ডেট চেঞ্জ করা যায় বলে দিই একবার যদি চেঞ্জ হয়ে যায় তাহলে
Within the time specified in the notice.
Let us stay
ওটাই বলছি। The magistrate may on receiving of the application
On receiving application after noticing the person responsible for such a grievance and
remove the encroachment,
responsible person
and may direct the police
for
assistant
the encroachment and taking
police
such
assistants.
evidence in order.
assistant engineer.
My lord, one indulgence, my lord. Any other day than Monday, my lord. I have some personal difficulty on Monday, my lord. I'm appearing for the state in this matter, my lord. Item number 11. Any
Monday we have fixed a similar matter. Why you will not be coming?
My lord, I have a matter in Bamboo Villa, my lord.
To be mentioned at the top, it will appear. You won't be coming to court.
Yes, my lord, but after 11.
My learned friend has some matter in some other court, my lord.
In the morning, first.
Okay, all right. Under the to be mentioned, marked
12 p.m.
না না একদম সকালে মাই লর্ড সকালে একদম করে দিচ্ছে
on Atho as fixed at 1 p.m.
My lord, deeply obliged.
1 p.m. ঠিক আছে মানে in the meantime I will file the supplementary affidavit and
give copies to them.
Deeply obliged, madam.
কেন তোমার কি অসুবিধা? That we will consider. Yes.
Grateful,
my lord. And for the appeal into this matter. My lord, one indigence, my lord. Sir, two time. I'm praying for adjournment, my lord. The last occasion I took time, last week I was sick and I could not arrange a conference with senior, my lord. Then, my lord, kindly fix the matter after 27th, my lord. Any day after 27th.
On the joint prayer of the parties, the matter stands adjourned. Release the matter for further consideration under the same heading in the daily supplementary list of this court on 11th February. Yes.
Grateful, man. Your lordship.
কি বলেন? Yes, next matter. Who is there?
My lord, I am for the petitioner, my lord.
So why you are there?
My lord.
Not today. Yes. Come and do it.
My lord, my lord.
Item 14, Your Lordship, I am for the petition.
Where is your other side who hears this?
Yes, Lordship, the other side is here.
Okay.
Before Your Lordship showing the impugned order, Your Lordship, may I just state the main brief facts, Your Lordship, what is the issue involved in this matter?
If I was to conclude it, I can conclude it first.
Pardon?
I am appearing for the respondents in both the cases. Respondent number one.
I am for Your Lordship, the writ petitioner in Your Lordship WPC.
So actually, I was in the midst of conclusion.
WPCT
58 of 2020, and Mr. Basu, Your Lordship, is appearing for both the writ petitions. And Your Lordship, may I just state the main issue, Your Lordship, involved in this matter? This is in connection with Your Lordship an interpretation of the BSNL rules, rule number 58. Now, in this matter, what happened? The employee, Your Lordship, was actually initially, he was in the Department of Telecommunication. Now, there were two charge sheets, Your Lordship, is involved in this matter, and the period which was given, that was 28th February 1995 to 30th September 2020, 2000. And Your Lordship,
February?
28th February 1995 till 30th September 2000. At that point of time, the employee was in the Department of Telecommunication. And the second
employee means the writ petitioner.
No, Your Lordship, the private respondent.
Writ petition.
Writ petition has been filed by Your Lordship, the BSNL challenging the order passed by the Central Administrative Tribunal.
To show us that order, we will come to know about the facts from there. Where is that order?
Order, Your Lordship, the certified copy, Your Lordship, is annexed here. And the impugned order, Your Lordship, is dated 11th of April 2019.
Ajay, you tell us what is the matter.
So that will be, Your Lordship, a little bit convenient. So this particular employee, Your Lordship, was initially in the Department of Telecommunication.
Which employee? This Maniklal Kaur.
Maniklal Kaur.
Very good.
And Your Lordship, the period, Your Lordship, when Your Lordship, the disciplinary proceedings was initiated, that is 28th of February 1995 till 30th September 2000. There are two periods. At that point of time, Your Lordship, the CCA rules 1965 was applicable. The period.
Now, when proceeding initiated on 28th of February 95?
No, Your Lordship, the period of, Your Lordship, the employment, 28th of February 1995 till 30th of September 2000. This was the period of imputation.
Period of?
Imputation, Your Lordship.
Period of imputation. Very good.
And thereafter, Your Lordship, the BSNL, Your Lordship, came into force, and this particular person was absorbed in BSNL.
So prior to that, charge sheet was submitted or not?
Yes, well, there are two charge sheets involved, and I'll indicate, Your Lordship, what are those particular charge sheets.
Very good. Now, after this, the which act came into operation?
No, BSNL CDA rules came into effect from 10th of October 2006.
All right.
But prior to that, BSNL came into force. And the another period which was involved in this matter was 1st of October 2000 from 6th of April 2005. Now, the second charge sheet which is under challenge, Your Lordship, before the Central Administrative Tribunal, that was issued on 4th of April 2012. Now, the main challenge was that this particular charge sheet was issued on 4th of April 2012 regarding the period mentioned from 28th February 1995 till 30th September 2000, when the private respondent was in the Department of Telecommunication, and from 1st of October 2000 to 6th of April 2005, when he was in BSNL. But at that point of time, BSNL CCDA rules 2006 was not into effect. So that's why the charge sheet issued under this particular rule is bad in law. This was the issue before, Your Lordship, the Central Administrative Tribunal. Now, one of the judgment coordinate bench, Your Lordship, held, Your Lordship, that this BCDA rules came into force on 10th of October 2006. So that's why you cannot issue any charge sheet in connection with the private respondent during this particular period, because at that point of time, BSNL CCDA rules was not there at all. And at that point of time, this CCA rules 1965 was applicable. So therefore, the initiation or Your Lordship, the charge sheet, issuance of the charge sheet itself is bad in law.
And what happened to the other charge sheet?
Your Lordship,
there were two charge sheets.
Lordship, there were first charge sheet, Your Lordship, was quashed. This is in connection with the second charge sheet, because there were three.
Quashed on what ground?
Grounds, Your Lordship, may Your Lordship hand over, Your Lordship, to list of dates, Your Lordship, where Your Lordship will understand, Your Lordship, that what is the for Your Lordship's convenience, I have just prepared. Because the dates are very important, Your Lordship, may I just indicate the dates? 10th of February 1975, the respondent number 1 was appointed as a telephone inspector at the Department of Indian Post and Telegraph. 4th of October 1982, the respondent number 1 was promoted to junior engineer and thereafter as subdivisional engineer on 31st of May 2000. 30th September 2000, the respondent number 1 worked in the Department of Telecommunication till that date. 1st of October 2000, the respondent number 1 was absorbed in BSNL because BSNL leadership came into the picture. Now, 5th of April 2005, CBI and Anti-Corruption Bureau initiated a criminal investigation against the respondent number 1 by registering an FIR. 6th October 2005, an order of suspension was passed against the respondent number 1 by BSNL. 10th November 2005, the respondent number 1 submitted a representation before CGM CTD for revocation of the suspension. Now, 10th of October 2006, BSNL Conduct Discipline and Appeal Rules 2006 came into force. Now, 23rd of March 2007, after completion of the investigation by the CBI, the concerned department of BSNL accorded prosecution sanction, and thereafter CBI filed charge sheet against the provisions of the Prevention of Corruption Act. 5th November 2007, the respondent number 1 was charge sheeted by BSNL. Thereafter, Your Lordship, in July 2010, the original application was filed before the Learned Central Administrative Tribunal, Kolkata, for revocation of the suspension dated 6th of October 2005 and quashing of the charge memo. 6th December 2011, the inquiry officer filed a report that the charge was not proved. Thereafter, Your Lordship, this particular 4th of April 2012, a fresh charge sheet was issued under Rule 36 of BSNL CCDA rules. 2012, the respondent number 1 filed another original application challenging the charge sheet dated 4th of April 2012 before the Learned Central Administrative Tribunal. 2012, Your Lordship, the earlier OA, Your Lordship, was allowed by the Central Administrative Tribunal. 30th April 2012, the respondent number 1 was retired on superannuation. 13th May 2013, a writ petition was filed by the petitioner challenging the order dated 27th April, passed in OA number such and such, and the order dated 13th May 2013, the Honorable Court dismissed the writ petition. 11th April, the original application OA number 946 of 2012 was allowed, and the charge sheet dated 4th of April 2012 has been quashed. This is the order, Your Lordship, we are challenging before this Honorable Court. And Your Lordship, the period, Your Lordship, we have mentioned that he was in Department of, Your Lordship, Telegraph from 28th February till 1995 to 30th September 2000, and BSNL, Your Lordship, 1st of October 2000 to 6th of April 2005. Now, Your Lordship, I'd like to, Your Lordship, show the order which is under challenge.
The first charge sheet which was set aside was issued on when was the first charge sheet issued, which has been ultimately quashed?
Yes, Your Lordship. The first charge sheet was issued 5th of Your Lordship, 5th of November 2007. Yes, Your Lordship.
5th of November 2007. Now, this charge sheet was quashed.
This was quashed.
Now, when was the second charge sheet issued?
That is 4th of April 2012.
4th of April 2012.
Yes, Your Lordship.
This imputation period is?
Lordship, the period, Your Lordship, I have mentioned, Your Lordship, that 28th of February 1995 till.
In the second charge sheet also?
Yes, Your Lordship, both, Your Lordship, when the person, Your Lordship, was in.
Tell us the first charge sheet in respect of the first charge sheet and the second charge sheet.
Lordship.
The imputation periods were same.
No, Your Lordship, the imputation periods were not same.
Not same.
Not
so, in respect of the first charge sheet of 2007.
Because the entire period was from 28th of February 1995 till 6th of April 2005. But I have broken because the person was in DOT.
We understand. Yes, we are asking you that the first charge sheet has been quashed.
Has been quashed.
So that is pertaining to the imputable period. Which period? Is the charges same?
No, Your Lordship, the charges are not some because in the meantime, Your Lordship, the CBI also initiated Your Lordship, some in criminal investigation. On that basis, Your Lordship, the second charge sheet has been issued.
So pertaining to the same charges which
No,
were
no,
quashed.
so not the same charges. I'll check, Your Lordship, and I'll mention, but not, Your Lordship, the same charges. Same charges.
Yes. Yeah, proceed.
Yes, Your Lordship. Now, Your Lordship, may I show Your Lordship the order which is under challenge? Because the Central Administrative Tribunal, because the Central Administrative Tribunal, Your Lordship, is simply sitting.
Counting the DOT period and difference.
The order which Your Lordship is under challenge, Your Lordship, kindly sees, because the Central Administrative Tribunal has not gone into the merits of the matter. They have only said, Your Lordship, that this particular charge sheet is actually should be quashed. The reason is the BSNL CCDA rules came in the year 2006, and once this particular rules came in 2006, you cannot issue the charge sheet in respect of the period which are prior, Your Lordship, to the main, Your Lordship, the commencement date. Mr. Basu, may I place the judgment and then, Your Lordship, I'll request Mr. Lordship, kindly take, Your Lordship, the first page.
But may I come back within 10 minutes? Yeah.
Yes.
Yes, Your Lordship. If Your Lordship kindly sees the first page, the application has been filed in order to seek the.
Which page of your statement?
The certified copy, Your Lordship, is the next, Your Lordship, with the writ petition. The first page, first internal page, Your Lordship.
At the last. You have not annexed a copy at the.
I tried my level best, because this particular writ petition, when it was filed, Your Lordship, is so haphazard. So we have checked each and every pages, and after page number 492, I think the last annexure, Your Lordship, is the certified copy. Even if it is not properly volumed, Your Lordship, nowadays it
should have come with a paper route. BSNL and statutory authority. We have to go through all the papers like
from the first day we are facing this problem, Your Lordship.
That is your problem, not our problem. It is your duty to make it convenient to the court. You turn this page, go to that page. A paper book would have solved.
I understand.
You will neither file a paper book and insist upon hearing of the matter.
Then, Your Lordship, kindly grant me some time.
No, they are suffering. We will dispose it of.
Yes, Your Lordship. I understand the inconvenience, but.
Yes.
I'm sorry, Your Lordship.
This is the duty of the council. That why should we trouble the court? All right, all papers are here. Let me file a paper. Yes, please, your case.
Lordship, kindly take the Lordship the page number 2, Your Lordship, of the certified copy. The application has been filed in order to seek the following reliefs. The reliefs, Your Lordship, has been quoted. If Your Lordship kindly sees the next second, Your Lordship, the prayer, direct the respondents to withdraw the charge sheet dated 4th of April 2012, framed by the respondent number 3, not being an appointing authority in violation of Rule 36, Sub-Rule 3, 4, 6, and 9, as stated herein before. Para 2, from the pleadings and the written notes exchanged between the parties, following position emerged. The applicant was charge sheeted in the year 2007, with a charge memo dated 5th of November 2007, indictment inter alia being as under. Your Lordship, this is the first charge sheet, Your Lordship, which I mentioned, Your Lordship, 5th of November.
When did BSNL come into operation?
In the year, Your Lordship, 2000, but rule came in 2006. That the Sage Sri Maniklal Kaur, while posted and functioning as SDE / technical central, the Calcutta telephones during 2000, committed gross misconduct in as much as he forwarded several bills of Messrs. A Enterprises such and such for drawing of 20 pairs PIP PIJF cables overhead by the firm, violating general financial rules and the rules contained in the PNT manual, which resulted in huge loss to the Calcutta telephones. In the estimate, such and such, although there was no provisions for drawing 20 pairs PIP-PIGF cables against the place mentioned in the relevant work order. The expenditure incurred for such drawing of cable overhead was booked against the state estimate. This is in contravention of Rule 131, 132, General Financial Rules and the rules contained in para 162 of the PNT manual. Further, Shri Maniklal Kaur, SD Technical Central Calcutta Telephones, forwarded bills of measures A enterprises amounting to rupees such and such booked against the estimate. He also certified the JTO Technical Calcutta Telephones and AO estimate. Calcutta Telephones have certified the funds availability under the said estimate. That by doing so, Maniklal Kaur has violated Rule 163 and 164.
So he was exonerated of these charges
Yes.
by on 28th of April 2012.
Lordship, the last paragraph, the inquiry officer found that the charges not proved. The disciplinary authority chief general manager Calcutta Telephones agreed with the findings and exonerated him from the charges. Video order dated 28th of April 2012.
So this 2007 charge sheet
Yes, Your Lordship.
pertains to the period when imputable period was. What was the period? There is no specification here.
At least I could not find, Your Lordship. I'll check, Your
Very
Lordship.
good. This was the first charge sheet opens by saying that Maniklal, while posted as SD Calcutta during 2000.
During 2000.
This must be prior to this.
Prior
Now,
to the
next charge sheet when then read thereafter while
Yes,
the
sir.
proceedings were underway.
Yes, Your Lordship.
Chief sheet charge sheeted on 7, read with 13 to
Internal
prevention of-
page 4, if Your Lordship kindly sees.
Yes.
Internal page 4's third paragraph. Your Lordship, it started with the charge sheet, which is under challenge.
No. Then 28th April 2012 was the charges quashed.
Quashed.
In the meantime, CBI inquiry.
CBI charge sheeted him and his wife on 23rd of March 2007.
Where you are getting that?
Lordship, just Your Lordship, internal page 3. The Lordship, I read it, Your Lordship, 28th of February 2012, which was exonerated, just below that.
Yes.
While the proceedings were underway, the CBI ACB charge sheeted him and his wife Juthika Kaur on 23rd of March 2007 under section 120B 109 of IPC and section 13(1)(9)(e) read with 13(2) of the Prevention of Corruption Act, having found him in possession of assets to the tune of rupees 69,41,729. He approached the tribunal in OA number such and such seeking revocation of suspension order dated 6th of October 2005 and quashing of the 5th of November 2007.
So that period, that is over, that has been quashed.
That is over. Now, Your Lordship, kindly sees the next page from third paragraph, where actually, Your Lordship, the second charge sheet came into picture. The applicant was once again charge sheeted on 4th of April 2012 by BSNL authorities for alleging acquiring assets disproportionate to his legal and known sources of the income, which he could not explain, satisfactorily accounts for, and for violation of some specified departmental conduct rules. The period in question was 28th of February 1995 to 6th of April 2005, which I mentioned, Your Lordship, regarding which included the period 28th February 1995 to 30th September 2000, when he was admittedly employed under the Department of Telecommunication, DOT, Government of India, as allegation pertains to the period while he was employed not under BSNL but under DOT. The applicant has allegedly invoking the powers by BSNL in terms of BSNL CDA rules as without jurisdiction, and has challenged the authority of the BSNL to issue the charge sheet in terms of Rule 36 of the BSNL CDA rules when his misdemeanor was determined by the DOT under the CCA rules. It is an admitted fact that the applicant has served DOT until he voluntarily adopted for absorption under the BSNL on permanent basis and was absorbed on 1st of October 2000.
Yes.
Should I mention that particular date also? Therefore, the questionable period can be broken into two distinct periods. First, from 28th of February 1995 till his absorption in BSNL on 30th September 2000. when CCA rules were applicable as is served under DOT. Second, from the date of the absorption in BSNL till 6th April 2005, when he served under the BSNL, when CCA rules were still applicable. BSNL having no framed rules until then. Because thereafter, Your Lordship, the BSNL rules actually came into the picture in 2006. The BSNL Conduct, Discipline and Appeal Rules 2006 was framed and came into force on 10th of October 2006. And thereafter, the applicant has pleaded that the period of occurrence from 28th of February 1995 to 6th of April 2005 should entirely be governed under the existing CCA rules 1995 and not under BSNL CCDA rules.
Yes.
CDA rules.
Then what is the finding? This is the issue.
Yes. The finding, Your Lordship, kindly come.
Paragraph 12.
All, Your Lordship, the submissions and judgments have been quoted. তো দিয়েছে না তার আগে ওটা তো বলে লাস্টে Lordship, if Your Lordship kindly take internal page internal page 13.
Yes.
Internal page 13, Your Lordship, after quoting, Your Lordship, the word started, the said judgment was rendered. Your Lordship, because at that point of time, Your Lordship, the tribunal, Your Lordship, dealing with, Your Lordship, Your Lordship, the interpretation of Rule 58. Whether, Your Lordship, the Rule 58, Your Lordship, of the BSNL CCDA rules is applicable or not. Lordship, may I read it, and then, Your Lordship, I'll show that particular rule, that why, Your Lordship, this period also, Your Lordship, the BSNL CCDA rules, Your Lordship, provides for the issuance of the charge sheet. The said judgment was rendered by the majority view, where even in absence of saving clause, in the words of the Constitution under Article 13 for one, reading, prosecution or action under repealed laws were allowed to culminate reasonably. Whereas, in the present case, as is evident from the language used in Rule 58, already enumerated supra BSNL CDA rules, though repeals earlier CCA rules, but also saves past action determinable under CCA rules. In view of such saving clause, although BSNL CCDA rules would have no retrospective operation, no transaction passed and closed in terms of CCA rules, but with regard to inchoate matters which were still not determined, had not come into force, had not begun or were pending when BSNL CCDA rules came into force, or were not yet prosecuted to a final decision under CCA rules, would still be determinable under BSNL CCDA rules. But such saving clause in no manner can be construed to take within the sweep such past acts and actions or conducts of an employee in DOT that were determinable by the DOT under the CCA rules. Such acts are punishable only by the DOT under CCA rules, cannot now become determinable under BSNL CCDA rules. BSNL would have no authority to exercise power to determine transaction determined by the DOT under the CCA rules. The sole authority to be exercised by the BSNL would only in terms of the Rule 58 of BSNL CDA and not otherwise. By framing Rule 58, BSNL cannot attempt to usurp the power of the central government to prosecute his employee while in his strength under CCA rules which applied to them, or take away the power of the DOT to deal with its pensioners to prosecute them in terms of CCA rules. Therefore, the action or transaction supposed to be passed or closed prior to formation of BSNL that were determinable by the DOT in terms of CCA rules cannot be determined under the BSNL CDA rules. They have to be determined in terms of CCA rules by the central government, as the BSNL CDA cannot be applied by the BSNL to the actions or transactions determined by the DOT in terms of CCA rules. However, we would note that the applicant has not challenged the constitutional or virus of Rule 58 of the BSNL CCDA rules.
So
Thereafter,
is
Your
it
Lordship,
that
the
the
judgments.
tribunal observation that though a pendency, a proceeding pending can be completed under the completed under the BSNL rules, as the charge was prior to that period,
Your
when he was a DOT employee,
Yes, Your Lordship.
that cannot be considered under this.
That is, Your Lordship, the crux of, Your Lordship, the judgment. The Central Administrative Tribunal simply said 2006 Act came into picture. These particular period as prior to, Your Lordship, that period when CCDA rules was applicable. So how you have issued the charge sheet under this particular rules, and whether the savings clause under Rule 58, whether it will save it or not.
Court says it will save it. On one hand says it will be saved.
Yes, Your Lordship.
First, internal page 13.
Yes, it says so, but ultimately, Your Lordship, the charge sheet, Your Lordship, was quashed.
It will, the proceeding will be saved.
Yes.
But the proceeding, you are not having jurisdiction since the period of imputation
or prior to that.
Is it, that is the
That is
idea?
the final, yes, that is the
can be saved, but you cannot quash it, you cannot conduct it
under the fresh rules.
That is the issue, Mr. Das.
The issue is that, my lord, I stated.
Or let him complete. Yes,
may I just, Your Lordship, place the entire judgment, and then I'll show Your Lordship the rules whether I can save it or not.
Very good. Yes, you finish.
Yes,
Then.
Lordship, paragraph 15, if Your Lordship kindly see. In the aforesaid context, we note that the BSNL CDA rules repeals earlier CCA, as it also saves exercise of jurisdiction under CCA, particularly in view of Rule 58, Sub-Rule 4, which savings clause should be construed, as already discussed earlier, as one that would allow BSNL to determine acts and actions or transactions or its employee while in BSNL prior to promulgation of BSNL CDA rules when CCA rules applied to them. It should, however, not apply to the transaction undertaken while in DOT service. Therefore, arguably and undoubtedly, Rule 58 empowers the BSNL to proceed and determine against the conduct or demeanor of its employee to whom, prior to promulgation of BSNL CCDA rules, CCA rules were applicable. This view would be strengthened by the decision infra. Then, Your Lordship, the judgments, Your Lordship, have been quoted. Now, Your Lordship, kindly take, Your Lordship, the internal page 19, Your Lordship, when the final observations are there. You kindly take internal page 19 and paragraph 19, Your Lordship.
Yes.
Rather, Your Lordship, kindly take paragraph 20. Accordingly, having understood the true import and implication of the judgment and order extract supra, we conclude as under. When the questionable conduct of an employee is while the employee was the strength of DOT prior to formation of BSNL, such conduct that was determinable by DOT under CCA rules would remain determinable under the CCA rules or the CCS pension rules, as the case may be, but only by the central government. When the questionable conduct is post-absorption of BSNL, that is past October 2000, while in disposition of BSNL, but prior to promulgation of BSNL CCDA rules, such as was determinable under CCA rules in view of Rule 58, Sub-Rule 4 of the BSNL CDA rules, would be determinable by the BSNL under CCA rules if the CCA rules stood already invoked, or else if not instituted, then under BSNL CDA rules. while such questioning conducts of the employee of the BSNL post promulgation of BSNL CCA rules will inferably and inarguably be determinable under the BSNL CDA rules. And finally, your lordship kindly sees paragraph 28. We notice that the misconduct is allegedly committed between 95 to 2000.
Where you reading, para?
The paragraph 21 at page, your lordship, internal page 20. That is, your lordship, the final concluding part. Having so concluded, we noticed that the misconduct is allegedly committed between 1995 to 30th September 2000, when it was determinable by the DOT in terms of CCS CDA rules. Given the saving clause in Rule 58 of the BSNL CDA rules, it will still be determinable by DOT and not by BSNL under the CDA rules. Therefore, the charge sheet issued in the present case by the BSNL under the guise of the exercise of the power under Rule 58 IBIDs was issued absolutely without authority and jurisdiction, and was therefore unsustainable and liable to be quashed. In the present case, having so concluded, we discerned that the applicant, who was erroneously prosecuted under the BSNL CDA rules for the period of service rendered in DOT, rendering the charge sheet a nullity, is not yet acquitted of all criminal charges, but he has been allowed to superannuate. In the aforesaid backdrop, having concluded that the disciplinary action under BSNL CDA for the alleged misconduct while serving under the DOT is illegal, while we have no hesitation to quash the charge memo and hold that the applicant would be entitled to receive all held up retiral dues within a period of 1 month from the date of the receipt of the copy of this order. We also grant liberty to the respondents to act in accordance with the law in regard to the questionable conduct while in BSNL and the outcome of the criminal proceedings. So simply, your lordship, the administrative tribunal says that you can't do it. Now, your lordship, may I show your lordship the Rule 58, Sub-Rule 4.
No, we have.
Lost.
This one you want to?
Yes, sir. We handed over your.
No, my brother doesn't have.
Oh. Lordship, I'm handing over a copy. And then a judgment of it. Kindly take, your lordship, the internal page 40, your lordship, in the bottom, your lordship, is mentioned. Page 40, your lordship, Rule 58. Whether, your lordship, I am covered under this.
Yes.
Repeal and savings. Any rule corresponding, because I have checked, your lordship, I have also brought that this particular rules are mentioned in, your lordship, all central government rules, your lordship. This particular saving clause is there. At least, your lordship, we have brought, your lordship, MSTC rules, your lordship, the other, your lordship, governmental rules. Same, your lordship, clause is there, your lordship, and nobody, your lordship, challenged it. Now, lordship, kindly see Rule 58, repeal and savings. Any rules corresponding to these rules in force immediately before the commencement of these rules and applicable to the employee to whom these rules apply are hereby repealed, provided that any order made or action taken under the rules so repealed shall be deemed to have been made or taken under the corresponding provisions of these rules, provided further that such repeal shall not affect the previous operation of those rules so repealed, and contravention of any of those rules shall be punishable if it were a contravention of these rules. An appeal pending at the commencement of these rules against an order made before the commencement of these rules shall be considered, and order thereon shall be made in accordance with these rules. The proceedings pending at the commencement of these rules shall be continued and disposed of as far as may be in accordance with the provision of these rules, as if such proceedings were proceedings under this law. 4. Any misconduct committed prior to the issue of these rules, which was misconduct under the suspended rules, shall be deemed to be a misconduct under these rules. So 58.4, your lordship, has saved. So even if you have conducted, during the earlier period, but that particular period is a deemed to be misconduct under this particular rules, and exactly the BSNL has done it on 4th of your lordship December, 4th of April 2012. They have mentioned your lordship regarding that particular period and issued your lordship this charge sheet under this particular rules.
In the charge sheet?
Yes, your lordship, 4th of April 2012. This is the charge sheet which is under challenge today before the.
That is in which page?
That is your lordship mentioned in page 55 of my writ petition.
No, where is the charge sheet? You have annexed it?
Yes, sir. Page 55. देखो 120.
Petitioner was absorbed in BSNL
in 2000, your lordship. 1st of October 2000.
he absorbed.
BSNL absorbed, your lordship, this employee. চার্জশিটটা কত নম্বর 120 দশম 100 দেখে নাও একবার।
Okay. Where is stated that Rule 58 has been referred to?
Page 55.
It has been the charge was.
Page 55.
Rule 36 of the Conduct and Appeal Rules.
Okay, page 55.
Was a hold inquiry. Now under Rule 36. No, this is not Rule 58 has not been referred to here.
No, your lordship. Rule 58 is the savings clause. Yes, sir.
In consonance with that, you are issuing the charge sheet. That is not spelled out in the charge sheet.
No, your lordship. That is not mentioned.
Very good. Now,
lordship, page 55, your lordship, is the memorandum dated 4th of April 2012.
Yes, we got it.
Yes.
And the period of imputation was?
Second page, page 56, annexure I, your lordship, is mentioned.
56 annex.
1995 to 4th April.
6th April 2005.
2005.
That is the entire period. That's why, your lordship, it has been broken.
Hard line. 28/2/95 থেকে 6/4.
He worked. During the tour, have acquired. Yes.
In the midst thereof, he was absorbed in BS.
Yes, your lordship. So that's why, your lordship, in the judgment also, it has been broken. And we have also broken, your lordship, for your lordship's convenience. That whether we can, your lordship, apply this particular rules or not, that is the only questions before your lordship, because
this was pertaining to 28th February to 95 till his absorption in 2020. That was for the old rules. He was absorbed on 4th of June 2000.
He was absorbed, your lordship, on 1st of
October 10th, 2000. So 1st October 2000, first period ends on that.
Yes, your lordship.
And the second period starts from 2nd October.
2nd October. 2nd October till 6th of April 2005.
Very good.
Problem was not that. The problem was the entire period, your lordship, when, your lordship, the CCS CDA rules was applicable. Because BSNL rules, your lordship, did not come, your lordship, in 2000.
It came in 2006. So you straight away come to the judgment delivered by the coordinate bench holding against you.
Lordship.
You differentiate the judgment.
Yes, sir. Lordship, prior to that.
2023 SCC online.
Yes, sir. Lordship, 2023 SCC online, Calcutta 485. Prior to that, may I just only indicate that whenever, your lordship, at the first juncture, when we moved the matter, the other side came and showed this particular judgment that the coordinate bench has already held it. So, your lordship, nothing to do. Now, we have moved before the Honorable Supreme Court against this particular judgment, and this judgment has been stayed. So, that is the entire, your lordship, problem today, that when the Honorable Supreme Court is in session of the matter, your lordship, I don't know, your lordship, I have spoken to Mr. Basu also, whether we should, your lordship, proceed with the matter and, your lordship, try to obtain an order, your lordship, which is. Lordship, kindly sees the last paragraph 5, till further order, operation of the impugned judgment shall remain state.
This judgment.
This judgment, Your Lordship.
Now,
Bharat Sanchar-
what is the present status? He has retired.
He has retired.
Pensionary benefits he is not getting.
Lordship, provisional pension we are giving.
Because you allowed him to retire.
Yes.
So now the financial loss caused, if any,
that is in connection
why
with
did
the-
you allow him to retire?
Lordship, because superannuation, the type, Your Lordship, the
The disciplinary proceeding concluded when? When was the final order of punishment passed? Prior to his retirement?
Here it was not actually, they challenged the charge sheet initially. And even the criminal cases are also
Now the
pending.
thing is that even if we hold in your favor, there is no avenue for him to face any disciplinary proceeding as well. The proceeding goes. Even if we hold in your favor, even if it revives, question of completion of proceeding will not arise because there had been a cessation of relationship now.
Lord,
He has retired.
Lord, I seek the
Super
indulgence to interfere. On the one hand, they are saying Rule 58 had scrapped
But
all the
Mr.
previous.
Das, one point is, please, we need your assistance. The Supreme Court is in ceasing of the issue pertaining to Rule 58.
My Lord,
No, Mr.
at that
Das,
point,
please,
I tell you,
please
Lord,
assist us.
I've seen that. I
No,
have placed
no.
their judgment.
No,
If that troubles their lordship, I can withdraw that. I can stand on my feet, my Lord.
You can withdraw what?
I can withdraw that judgment. For the time being, I don't rely on that. I stand on my foot, my Lord. Lordship.
Very good. We understand that.
No,
But
they are again and again showing there. I am not implicit there. If I am implicit there, case is not settled, my Lord.
No, you got the order. You got the order in consideration of another judgment of the coordinate bench. This
Yes, my Lord. I bow down to your lordship. I
the
stand on my
tribunal
feet.
considered this judgment.
Ah.
Did the tribunal consider this judgment of Justice Tandon?
No, Your Lordship, this judgment, Your Lordship, passed on 1st of
1st
February
February
2023.
2023.
Yes.
And tribunal did not consider. Then when did they show this judgment?
Your Lordship, when we moved, Your Lordship, for obtaining the stay order,
Lord,
at that point of time, Your Lordship, the respondent came and said that this point has already been
so many
adjudicated.
judgments, and today also I am ready with all the judgments. All the judgments.
We understand, Mr. Das, but will it not create further complications?
No, that will not at all.
Because the point of law has to be determined by the
No, I
Supreme
tell
Court.
you, lordship. Lordship can remember my submission. Then lordship allow me to submit for.
Similar issue is pending before the Honorable Apex Court.
My Lord, the ratio of the judgment is in my favor. Ratio of the judgment. Because the check period, I tell your lordship.
That has been stayed, Mr. Das. Please try to we are
No, they are now banking upon that. They have gone to Supreme Court on that. Better, why didn't you implead me as a party there? I could have settled it right now there in one day, but they are prolonging it. BSNL is definitely not with a clean hand, my lord. And as far as my case is concerned,
Second order.
I am not relying on.
So you are saying
just a passing by, I have given some observation, but I have other judgments to show that. My lord, the BSNL, they say I was relying upon for 58 because my gratuity is held up now. That is the point. Gratuity is held up my and my lord, I say the BSNL gratuity. They say Rule 58 is scrapped, but they say 69 1C is there. No, it is not there. Rule 58 does not scrap all the existing rules, save and except where it is BSNL rule is silent. Rule 64, Rule 61(3), they say Payment of Gratuity Act. Yes, it is the Payment of Gratuity Act that they are to follow. They are not bound by that 69 1C. That I have cases, my lord, on that point. 69. A High Court of Judicature in Allahabad, my lord.
This matter
They are
came
very
in
nicely dealt with the matter.
This matter came in December, and Your Lordship, the Honorable Supreme Court fixed the matter in the March, Your Lordship, 2025 list.
Any date fixed?
Supreme Court nowadays, Your Lordship, only gives Your Lordship in the month of And then after your lordship,
My lord,
like case status comes and date
no,
comes.
that point I have argued, my lord. If your lordship wants me, I can sum it up in a very short matter. My lord, the BSNL was framed under order 39/2010, 1 day prior to coming out. And that order under section I
All right, let him finish. Let him finish. Yes, what more you want to show us?
Lordship, the
Huh? 1 PM এর ওই এসছে নাকি লোক? What, yes, Mr. Chakraborty, he has, Mr. Bandyopadhyay has, what happened?
My lord, he's on the way, my lord. My lord.
Yes. You say,
now the Honorable Calcutta High Court, your lordship, has clearly said, your lordship, that 58 is not applicable. Because this judgment is very clear. Justice, your lordship, the Honorable Justice Tandon and Honorable Justice Bishwas is completely against me. It says 58 not applicable. Any charge sheet issued prior to the period, your lordship, is void, is bad in law. Against that, your lordship, we have preferred an appeal whether your lordship 58(4) is clearly said that if the misconduct, your lordship, is there, then I still, your lordship, is a misconduct under these rules.
that is pending consideration between.
I do
Before the
not,
Honorable
I do
Supreme
not
Court,
know how
because
he is attending the word misconduct. Their departmental inquiry, roving inquiry for 5 years under BSNL CDA rules.
দেওয়া আছে।
That allows me to come out flying colors.
decide
269. 269.
Extension করতাম।
260.
No, then tell us when he had been allowed to retire, why you are withholding the gratuity then?
Lordship, I think Rule 69 on the basis of your lordship, Mr. Your lordship, on the last occasion has shown your lordship Rule 69.
69 of what?
Of the CCS CDA rules, pension rules, where your lordship has mentioned, your lordship, that if the criminal proceeding is pending, because the CBI charge sheet is there, lordship, the criminal investigation is still going on. In that particular case, whether your criminal trial is going on, whether your lordship is entitled for any other benefit or not, because
this was 69.
69 months C does not apply. My case is there. I have got judgment of Allahabad High Court and very
69
good judgment, my lord. I will place it before your lord. It is a corporate body. He says partly he is right, my lord. 58 scraps or 61 lordship will find.
এটা লাস্ট টাইম দেখি আর আমরা কি দিয়ে দিয়েছি প্রভিডেন্ট পেনশন ইজ গেটিং
Consideration এই কারণে আসছে this is coupled with the issue as to whether at all the disciplinary proceeding was made.
না সেটা ঠিক আছে কিন্তু জুডিশিয়াল প্রসিডিংসটা ডিসিপ্লিনারি প্রসিডিংসটা judicial proceeding is going on. Yes, it is completed now. এই মামলার হলো ওরা দেবেন সেটাই যথেষ্ট করে এটা দেবেন Interesting activity.
আমার যত পেয়েছি
তাহলে ও হারবে কোনো
বাড়ির জাজমেন্টটা দেখি এটা বলে দিই
69(1)(c) অ্যাপ্লিকেশন আমরা এই সময় তো করতো মামলাটা 69 মামলাটা ছিল চার্জশিট
চার্জশিট
Procedure.
Proceed. Proceedings actually কিন্তু judicial proceedings still চলে গেছে এটা। এই সিগন্যাল পয়েন্ট নিয়ে রাখছিল আগে তখন কাছে
Under the Payment of Gratuity Act, there is no provision of withholding of gratuity.
PF he has
If
got.
Only it can be, the other day I argued that if he has caused any pecuniary loss to the department under section 6(4), I suppose, 4(6), 4(6). So it can only be, to that extent it can be recovered. But the departmental inquiry, which is in a roundabout with the same charge, but of course they have been very careful enough. From 110-2000 they did it. 110 to 2000 till that date. They have exonerated me. I have come out flying colors. So naturally that period goes. The earlier period, of course, my charge sheet was, I challenged on the ground that the check period was from 28 to 1995 to 6/4/2005. I have left some leeway that they could have done it from the date of my
So you are wanting us to
12
decide.
to 2004.
So if we understand you, you are wanting us to decide your right to avail the gratuity, irrespective of the issue as to whether the proceeding at all was maintainable. That is what you are wanting from us.
Lordship.
That whatever has happened, let the Supreme Court consider, but give me my gratuity.
But they have not made me parties there.
Huh?
That's not the order, Your Lordship.
They are intentionally delaying that. Otherwise, my lord,
that is another, you are not party to the
Yes.
I am not. So I am saying, if that is
your
stopped,
right to be implicated in that proceeding.
Lordship.
When a point,
That is my point. I am not a party there.
Similar issue is pending. Whether in respect of the misconduct committed by a employee prior to promulgation of the
BSNL-CC rules
can be governed by the BSNL rules.
No, that's I argued, my lord. Even I can sum up what I argued the other day.
You can advance argument.
You can advance argument, Mr. Das. We are not having any problem. But the thing is that there is to a final solution. 69(1)(c), yes, you are right. Supreme Court said that if better benefits are available, Payment of Gratuity Act, they have to disburse it to you. That is Kalra's judgment, Supreme Court has said. Now the thing is that the subsistence of the proceeding is in question, and 69(1)(c) refers to a judicial proceeding, wherein a criminal case is still pending against you. In this scenario, Mr. Das, suppose upon detailed hearing we hold against you, where will your remedy lie?
Of course, my lord, of course, we are in a Fox pass, my lord.
Fix, yes.
Before the Supreme
The
Court.
catch-29 issue. Now today, suppose we deliver a judgment in your favor, saying that no, whatever it is, we are not concerned, you give the gratuity.
I understand, my lord. But
now it is a statutory organization. It is not that if ultimately if Supreme Court decides against them, you can certainly claim this gratuity
we have
along with interest.
We have an Allahabad High Court judgment, my lord. Lordship can peruse it. It is a very good judgment, I find. Of course.
Allahabad High Court full bench.
But the division bench, my lord. Division bench, and they have said
you cannot withhold. We understand, Mr. I have delivered a judgment saying you cannot withhold.
Lordship.
Myself sitting with Justice Uday Kumar, we have delivered a judgment saying this argument which you are making, that which is the beneficial provision. If Payment of Gratuity Act grants you parallel remedy to get the gratuity.
I have seen that judgment, of course.
Yes, we have delivered.
But this judgment is very specific.
We considered this judgment, if I am not mistaken.
It is a very specific judgment, my lord. Take it out.
Into
page 38. 49. Para 49. Na?
But how can we, Mr. Das, how can we
I understand, my lord. Now we are in the midst of a but it cannot my lord, what I am saying, my lord, subject to that Payment of Gratuity Act, if he has done any misconduct, that much of amount they can Yeah, but they cannot withhold. I am relying on the Parent Act, Payment of Gratuity Act, that never talks of withholding, that talks of forfeiture, that talks
So,
of
Mr. Sengupta, if your
recovery.
BSNL authorities,
Pecunia-
if the BSNL authorities proceeds on their sweet will, that we will keep the matter pending.
No, no, Your
before the
Lordship, I
Supreme
have shown Your Lordship the judge.
Rest of the part may be given.
Stay has been granted, and Your Lordship, the counter affidavit has been filed, I think. And Your Lordship, the matter is fixed in the monthly list of March, there before the Honorable Supreme, not monthly list, any day Your Lordship will come in the month of March 2025. Lordship, I have given Your Lordship the last
I
one.
tell you one thing. That case, Supreme Court reply, the party has come to me, I have to write the reply. I tell you,
I cannot,
so
Your
far.
Lordship.
You will
So-
be contesting that.
Though I am not contesting that. He has requested me, Mr. Das, you do it. I said I will do this. Let me do my case first here. I'll do that. So that
You are asking us to deliver a hard task.
I also know, my lord.
When our elder brother is in scene of the matter.
So, my lord, midway, I say part of the gratuity should be released. There are occasions.
No, that we will
Art
consider.
will not proceed. Judicial proceeding is
Lordship,
pending.
that also I know, my lord.
There is a bar.
But since 2012, my lord,
Pending before the Supreme.
my lord, of 13 years, his gratuity is held up. And he's lying in bed, my lord. My client could not come. He's lying in bed. Undergoing treatment. He cannot get even medical card, everything, because he's not a regular pensioner. That is the whole difficulty I am
But
facing.
Mr. Das, please tell us, how can we segregate this issue of gratuity and give you the benefit? When Supreme Court is
Lordship can rely upon that judgment, rely on payment of gratuity act. Actually, my lord's
Mr.
judgment is
Das.
also there. My lord also discussed. Of course, I leave it to your lordship, my lord. I know where my lord stand and where I stand. I know that very well, my lord. But how can we accommodate them? They are not with clean hands or clean mind. Since 2000.
Mr. Das, go and finish up the matter. It is in March. Supreme Court, you argue and finish it up. Come back to us.
My lord,
we will be placed in a position.
Nowadays, I cannot go to Supreme Court, my lord. I am old enough physically. Before that, I went there. But in any but in any view of the matter, the charge sheet is not maintainable.
Mr. Das, we do one thing. We keep it in the month of March. If your Supreme Court matter is not disposed of, you make your argument as regards application of payment of gratuity, whether we can release the gratuity.
Very well, my lord. Very well. Then towards the end of the March, my lord, second week, I'll not.
In course of hearing, Mr. Sengupta, learned advocate, appearing
My lord knows everything.
No, no, I'm not asking for
My
your
lord,
lordship.
that
I'll
day,
prepare the paper.
No,
my lord, that day,
we do
gratuity-
forget, but it comes back to our mind when we again hear it.
So that's why, your lordship, I'm telling your lordship, I'll take the initiative and prepare the paper book so that I
That
can.
is your choice. We can,
I'll
because
do it.
if in any manner this filing of paper will further delays
No, no,
the
no.
matter,
Lordship, second, I'll serve it to the other side. I'll come.
In the meantime, if you can do.
Yes, yes.
can do. Dealing with 500 pages brief.
it was a difficult task, my lord. It was a
3 or 4 volumes, that would be.
it was a disarranged reply that we got. We writ petition we got. We put it in order at much difficulty.
yes, what happened, Mr. Bandhu?
Gratefully.
You got the
I did not mention yesterday because my lord, my officers is not in a position to give that instructions because it's beyond the NIT. They say that then again I'll have to move the file to the department, take the consent from the department, and then only I can.
pass our order.
Your lordship will make it CAV or whichever way your
No
lordship
CAB, we will pass it.
or your lordship will pass it.
এই শোনো ওই বুধবার টুধবার রেখে দাও অর্ডারটা দিয়ে বুধবার কি আছে কি বলি
হ্যাঁ বৃহস্পতিবার 23 তারিখ
বৃহস্পতিবার 23 তুমি থাকতে থাকতে হতে না চলে যাবেন তো স্যার 21 তারিখ কি
21 তারিখ
pass our orders on Tuesday 1 p.m. Tuesday বললে তো হ্যাঁ 21st
21st. Grateful one.
Grateful.
ওটা তুমি মার্ক করে রেখে দিও and if you get instruction in the meantime give us
My lord, he cannot give me the instructions.
আচ্ছা ঠিক আছে pass our orders
Milord, may I get your lordship's kind leave to mention one matter? Milord, item number 73 of yesterday's list. Milord, it's a part matter. Milord, if your lordship kindly sits singly on the next day, Milord, kindly fix the matter at the top. Because it's a part matter and আজকে লিস্টে নেই Milord, if your lordship kindly fix this part matter at the top on the next day.
What's the matter about?
Milord, matter is Milord, whether we are entitled to get cumulative interest on the basis of certain fixed deposit certificates or not.
Oh. But I
Milord,
don't know when
lastly it was taken.
I shall get opportunity to sit singly again.
Milord, whenever your lordship will sit.
আচ্ছা ওটা উপরের দিকে দিয়ে দেবেন
Item number 73. লিখে দিচ্ছি I'm grateful before your lordship.
Yes, who is for item number 1?
Milord, item number 1 I am for the petition.
But I'm for the state.
Sorry, you don't find any justification to interfere with that. Okay, accordingly, the same is dismissed.
I'm grateful.
Hmm.
I appear for the appellant, my lord. My lord, I'm being led by Mr. Mujumdar, my lord. He'll be here, my lord. My lord, it's an appeal arising out of an order of my lord. My lord, I'm being led by Mr. Mujumdar, my lord.
My lord, deadly. My lords, we have filed an application in the nature of Order 41, Rule 27 to bring on record not the depositions of the parties.
Who has filed?
The appellant bank.
You've given copies to him?
We have.
My lord, we have received the copies, my lord. On Monday, my lord, I could prepare the affidavit in opposition, my lord, to that. My lord, but since, my lord, to be for fairness, my lord, we are opposing. But since if we wish, it will further delay the proceeding. We are opposing the application, but not using the affidavit, my lord.
All right.
We can play ball.
Yes.
We have prepared a short list of dates note for your lordship's consideration. We have to copy it up. Not the point is not very short. But there was a charge framed against the writ petitioner alleging him of writing scandalous against a woman employee on the wall, implicating another officer of the bank. This happened on a Saturday between 2 to 4. Now, on Monday, there was an uproar in the office over that scandalous writing on the wall. Now, I need not read it out for your lordship's consideration. I can only show not from the charge sheet what was the scandalous words used in that writing. Please come to page 39. Page 39 of the paper book. You had written abusive, indecent, obscene and disparaging remarks against Kumari Nupur Roy Chaudhuri, clerk grade 1, a lady employee of our bank, amounting to her character assassination and causing indignity to her on the wall adjacent to the staircase between ground floor and first floor, 8th step to 14th step, when counted from below, at about 16:45 hours on 26 June 1993. The exact writing in Bengali and English are reproduced below. But I skip over.
Yes.
Further, you had also made disparaging and derogatory remarks against Sri P.K. Dholakia, development officer in the above writing, which amounted to his character assassination. By indulging in the above acts, you have tarnished the image of National Bank and created an unhealthy atmosphere in the bank's premises. You are therefore charged with having committed an act of serious misconduct within the meaning of Rule 47 of the rules and acted in a manner which is unbecoming of an employee of National Bank, the charge sheet is accordingly issued to you under Rule 47 of NABARD so and so. The documents in possession with the bank in support of your above charges are as follows. Letter of documents from the Security Services of India, the agency entrusted with the job of providing security of the bank's premises, indicating your involvement along with others in the act of writing on the wall. A letter from a staff member having seen you in the act of writing on the wall on 26th of June 1993. Certified document giving evidence of exact words written by you on the wall. You are hereby called upon to answer the above charges in writing within 10 days, so and so. Now, this was followed up by an inquiry.
This charge sheet was only against him.
Against 4 similar charges, but not 3 were transferred by way of penal action, and he was imposed with the punishment of stoppage of 3 increments ultimately.
There were total 4 accused. Against all 4 of them, proceeding was initiated.
All of them were proceeded against, 3 were transferred to a different branch.
And they have also been, all 3 has been transferred prior to conclusion of the proceeding.
No.
They were not given any punishment.
He was given this punishment because he was seen to be writing.
No, in respect of the other disciplinary proceedings, what had been the fate? Same charge.
Similar charge. They did not write, they were standing there. That was the allegation.
Yes.
The inquiry officer in his report found the delinquent employee to be not guilty. So there was a disagreement by the disciplinary authority. He scanned the evidence and said, on this basis, I come to a finding of guilt against you. And thereafter, the punishment was imposed, which was challenged in a writ petition. The Honorable Court held that treat this disagreement to be tentative and you give a reply. So, on treating this finding to be a tentative one, the delinquent gave a reply. The disciplinary authority then passed a penalty order which was confirmed in appeal. Now, the Honorable Single Judge set aside the penalty order principally on 2 grounds, 3 grounds rather.
Yes.
The disciplinary authority had misconstrued the order of remand.
Yes. Yes.
Secondly, he should not have reconsidered the matter entirely.
Yes.
Thirdly, the second disciplinary authority really acted as an appellate authority.
Now, what was the second? He should not have reconsidered
the matter entirely. He should not have.
So, he meant to say it was a limited remand. I see. Yes.
Now, that's why we are in appeal before your lordships. Now,
he is still in service.
No, he had attained the age of superannuation, getting his dues, whatever it is.
Suffered the punishment. Yes.
Now, please come to the penalty order first, at page 77.
Yes.
Now, if I read this order in its entirety,
this is the upon remand.
On remand.
Now, will you show us the order of the High Court first?
It's at 175.
Oh, it is a longish order.
178.
No, page 66 also. No, the order of remand by which it was sent back.
Oh, the order of remand, Justice Shen Gupta order. Now, that's at page 66.
All right. Now you are showing us page 77. Yes, tell us.
Not the penalty order at page 77. The CAC has raised, no, this is he records that in terms of the court's order, a second show cause notice and a tentative one was issued then. The CAC has raised the following contention and issues in his reply dated 1st June 1994, and my findings are as under. The contention of the CAC that the finding of inquiry officer and competent authority are contradictory to each other. The competent authority in his order dated 21st May 1994 has given sufficient reasons for his not agreeing with the finding of the inquiry officer. Competent authority has analyzed the entire evidence available on the record. The inquiry officer has not considered all the evidence, but only part of the same in his report. The reasoning given by the competent authority are indicated in para 6(1) of his order. Stop. I agree with the same. The next contention of the CAC that he was not supplied with copies of the enclosure to the inquiry officer report is not true. CAC requested for supply of the said enclosure by his letter of 27th May 94, to which reply was sent by the bank on 28th May 1994 vide letter number so and so. It was made clear in CAC all the documents were made available to him on different dates during the inquiry. I find that there is no merit in the said contention of the CAC. The CAC has further contended that the charges contained in the charge sheet are baseless, false, motivated, prejudiced, unspecified, malafide, and unwarranted for the reasons that the enclosure to the EO's report is not provided to him. The interdisciplinary proceeding was replete with a procedural lacunae, which is manifested from the day-to-day inquiry proceedings. The CAC has given certain examples as indicated in subpara B of para 3 of his reply, that the bank has denied him chance to reply to the said charge sheet by withholding certain documents as demanded by him in his letter dated 4th August 1993 and 12th August 1993. That he was not allowed inspection of documents on 13 September 93 as indicated in the charge sheet enclosed with the inquiry report. His contention is based on the proceeding of inquiry dated 30th September 93 do not indicate that the inspection of documents was allowed to him. He was not provided with the list of documents by the inquiry officer or presenting officer before or during the inquiry proceeding. Certain documents in the inquiry proceeding have not been identified with any exhibit number in the inquiry proceeding, and copies of the same were not supplied to them. He was not allowed to be examined himself, for which he is entitled to defend himself. The above contentions raised by the CA were also raised in the CO number so and so, and the same has been rejected by the Honorable High Court at Calcutta in its order dated 30th November 2001. The Honorable Court has held as under. Having heard the respective submission of the learned lawyers, Mr. Sengupta's contention as against impugned first charge sheet and also against the inquiry proceeding is not acceptable to me in view of the fact that in spite of his grievances of non-compliance of natural justice, his client could participate in the domestic proceeding, and from the record I do not find that his client has suffered any prejudices. He availed of full opportunity afforded by the inquiry officer. Mr. Chaudhary has rightly agreed when no injury or prejudice has been caused, the compliance of natural justice is not a right. In view of the above, and that in fact the CAC was given ample opportunity to defend himself, and no prejudice has been caused to him in any manner, there is no merit in the aforesaid contentions raised by the CAC. The next contention of the CAC is that the analysis of the evidence by the competent authority while passing second show cause notice vitiated for the following reason. That the allegations listed in para 6A of the competent authority's order indicating chain of events are false, unsubstantiated, unsupported, and in no way connected with the charges, thereby rendering it outside the purview of the inquiry. That the competent authority made no mention about the statements on the aspect of purported letter K demonstrated by both the alleged victims, Sri Dholaki and Ms. Chaudhary. There is a difference in the name of security guard in the order of competent authority and letter written by the security guard. Therefore, there is material variation of identity of one person alleged to have reported to SSI, that's the security agency, which prompted SI to report against CAC, forming the basis of charge sheet. The competent authority has misconceived in his analysis as stated in para 6(1) of his findings dated 21st May 1994 that there is no contradiction between the depositions of DW 2, 3 and 1. Competent authority has misread inquiry officer's confusion, and subjective competent authority has done great injustice by introducing his personal feeling by observing natural impulses in respect of a lady employee faced with such a terrible situation. CAC has further contended that the competent authority is silent on the matter relating to a joint representation of PIDD section dated 2nd July 93, wherein Mrs. A.B. Khan, being a signatory, had demanded of the management the apprehension and punishment of the guilty. One of the witness, Dr. Mrs. A.B. Khan, has signed two contradictory and mutually exclusive letters of 2nd July and 5th July 93. The last contention of the CAC is that the competent authority has manifested his personal bias to the CAC, forgetting that the question put to Srimati Talukdar was neither defamatory nor slanderous, but such remarks used to be made by Srimati N. Roy Chaudhary in office. The competent authority has recorded the reasons for his differing with the conclusion of the EO. In para 6 of his order dated 21st May 94, the competent authority has analyzed the full evidence given by witness 1, Sri P.K. Dholakia, and came to the conclusion that there exists a chain of event culminating in writing on the walls of the office premises wild, defamatory, derogatory, slanderous remarks on the victim. I agree with the findings of the competent authority. As regards the confusions created by the witness about the name of guard and about the name of charge-sheeted employee, the competent authority has come to the conclusion that by not examining one witness, it does not automatically follow that other evidence produced in that regard lose their importance. The competent authority has been satisfied as regards the name of the charge-sheeted employee and name of the guard on the basis of letter dated 6 July 1993 and the letter from the security guard. I agree with the findings of the competent authority. The competent authority has also analyzed the evidence given by Dr. Mrs. Khan and come to the conclusion that the finding of the inquiry officer is not correct. Further, there are no anomalies in the evidence of Mrs. Khan. Further, the observations of competent authority on the behavior of witness Dr. Khan cannot be considered as any bias against the charge-sheeted employee by any stretch of imagination. The competent authority has appreciated behavior of the witness while analyzing the evidence. This would not amount to negative approach towards CAC. No adverse inference can be drawn against the competent authority on the above count. The question put to Srimati Talukdar by the defense representative was not relevant for the purpose of inquiry. Such defamatory and slanderous question cannot be justified by the CAC by any stretch of imagination. The inquiry officer should not have allowed such question. The observations by competent authority in this regard are justified, and the same cannot be considered as a bias against the CAC. After considering all the materials and evidence on record, and all the aspects of this case, and in view of what is stated above, I do not find any merit in the contentions raised by the CAC in reply dated 1st June 1994. I therefore pass the order imposing on charge-sheeted employee the penalty of reducing the pay by 3 stages in his scale of pay for a period of 1 year from the date of this order, having the effect of postponing the date of future increment, and his period of suspension may be regularized by grant of extraordinary leave not counting for increment. The period shall be treated as break in service for the purpose of gratuity.
So this, if it is treated as break in service, then the service tenure gratuity calculation falls down.
Yes. But a period of suspension is normally to be reckoned as a period not spent on duty unless the service rules specifically provide for so. That is, in the event of the final outcome of the inquiry being against the employee concerned, then this period is not to be normally counted as a period in service for the purpose of calculation of dues. If he is exonerated, then of course it counts as service, the period of suspension. That's the normal rule.
The break in service is a punishment, misconduct is a punishment under your
No,
rules.
no, it's not dias non. But this period of suspension has not been counted only for the purpose of calculating his gratuity period.
That is a substantial amount. No?
Let's say 2.5 years. The period of suspension, since the charge was found to be proved, so he was not to be treated as an employee who has spent his duty for this period. So maybe 15 days, maybe 15 days or 1 month salary is deducted for the purpose of gratuity.
No, the proceeding continued substantially. No? The
Yes,
charge
yes.
sheet was of the year 1993,
Yes.
and this order was passed
94.
94.
And the final order was passed in 2001.
Yes.
Similar, this was the order passed not by the disciplinary authority which was challenged before the Honorable Single Judge. Now, if your Lordships kindly come to page 175, the relevant portion would be at pages 183 onwards.
Page 185.
Begins at 175. Let I draw your Lordship's kind attention to internal page 6, page 183.
Yes.
Please take the third paragraph from the top of that page. The sentence begins with the words, the delinquents said that they had left the office on that day by 4 p.m.
Yes.
On this basis, the inquiry officer came to the findings that the charges against the writ petitioner as well as the other charged employees were not established. Then the matter came before the competent authority or the disciplinary authority. He appears to have examined the inquiry report. He came to the conclusion without giving any reasons or hearing the writ petitioner that the conclusions of the inquiry officer were not correct. He summarily held that the writ petitioner and co-delinquents guilty and imposed the proposed punishment. This order was directed to be treated as a tentative order by His Lordship. In obedience to this order, the petitioner had filed his written submission or reply. In my opinion, the second disciplinary authority had completely misconstrued the said order. He was not asked to deal with the objections of the petitioner, but to reconsider the whole order in the light of the objection filed by the petitioner. In the decision made by the second disciplinary authority on 8th May 2001, it made an appraisal of the first disciplinary authority's order with regard to the objections put forward by the petitioner. It commented on the objections, rejected all of them, and upheld the order of the first disciplinary authority. Instead of acting as the disciplinary authority, the second disciplinary authority acted as an appellate authority without advancing intelligible reasons. It concurred with the findings of the first disciplinary authority without an iota of reasons. For example, take a look at paragraph 4 of the impugned decision. But paragraph 4 is quoted. The competent authority has recorded the reasons for his differing with the conclusion of the EO in para 6 of his order dated 21st May. The competent authority has analyzed the full evidence given by the witness, one Dholakia, and came to the conclusion that there exists a chain of events culminating in writing on the walls of the officer premises while defamated so and so. This does not make any sense to me. Thereafter, the second disciplinary authority states, as regards the confusions created by the witness about the name of the guard and about the name of the charge-sheeted employee, the competent authority has come to the conclusion that by not examining one witness, it does not automatically mean. I have read that. Please come to the next paragraph. Finally, it came to its conclusion in the following terms. Paragraph 6 is quoted. But then on the next page, the appellate authority's order is quoted. Up to the penultimate paragraph. Then, let me first deal with High Court of Judicature at Bombay versus so and so. A 3-judges bench of the Supreme Court file was considering the status of the report of the inquiry officer. In an inquiry, the inquiry officer collects the evidence. The delinquent officer has the opportunity to meeting the charges against him. The inquiry officer expresses his view. Thereon to be considered. These are not all well settled principles. I need not trouble your lordships at this moment with the well propounded principles of law. Please come to the last 2 lines of page 186. I'm sorry, the penultimate paragraph of page 186. In this case, the court intervened and directed the second disciplinary authority to take the findings of the first disciplinary authority as tentative and take a final decision after allowing the petitioner to show cause. The delinquent was not given any hearing. The second disciplinary authority in its ruling of 8th May 2001 has narrated in a cursory manner how it was dealing with the objections of the petitioner, which tantamounted to total non-application of mind, acting mechanically and arbitrarily. This runs contrary to the first portion of the order. Therefore, the law that evolves from these two decisions is that the report of the inquiry officer is just a recommendation on the evidence collected by him and the submissions made before him. Whether the disciplinary authority is in agreement with the inquiry officer or not will arise after he goes through the evidence and the findings thereon and hears the submissions of the delinquent. Thereafter, it will indicate its affirmation or disapproval of the report with reasons. Even more is this obligation if the inquiry report exonerates the delinquent and the disciplinary authority proposes to change it. This kind of an opportunity was not provided to the delinquent. The second disciplinary authority acted as if it was an appellate body. The findings of the first disciplinary authority was commented upon and approved by the second competent authority. The reasons which were advanced by the second disciplinary authority were in the form of comments on the findings of the first disciplinary authority were not unnecessary. In what Rup Singh Negi is quoted, please come to the next page. Just after quotation from Rup Singh Negi, the third line from the top of that page. In my opinion, if an inquiry report cannot be set aside on the ground of absence of reasons to support a finding, the order of the disciplinary authority can also be set aside on the same ground. But I skip over the next paragraph because this was only referring to another Supreme Court judgment. In this case, as it appears from the report of the inquiry officer, quite a few witnesses for the prosecution only expressed their opinion as to what had happened and who in their view had committed the wrongful act. They had no first-hand knowledge. The only basis of the first competent authority's decision was the evidence where Dr. Mrs. Khan, who is said to have noticed the incident. This is very seriously controverted by the evidence of the defense witnesses. On that day, the office where Dr. Mrs. Khan worked was closed and that she was not anywhere seen around the premises. On this basis, the inquiry officer had exonerated the delinquent. I do not see any compelling evidence on which this verdict could have been overturned. Equally disappointing is the order of the appellate authority. Now it quotes, then the appellate authority proceeded to make its own observations, assuming the findings of the disciplinary authority to be established. The relevant rules with regard to disciplinary proceedings against the employees of NABARD have tried to protect the interest of the delinquent to the maximum extent possible, as well as ensure that proper justice is done to the case. It has a procedure for inquiry. In the inquiry, the evidence in support of the charges and the defense, together with the submissions of the prosecutor as well as the defense, is documented. The inquiry officer, after a very careful examination of the whole case, is required to present his opinion with regard to the guilt of the delinquent with supporting reasons. The entire records are then to be placed before the disciplinary authority. The disciplinary authority has to give an opportunity to the parties to file written submissions against the inquiry report and hear them specially. So, if the disciplinary authority wants to change the recommendation of the inquiry officer of not guilty to guilty, then the disciplinary authority is required to give its own reasons, concurring with the findings of the inquiry officer or disagreeing with them. On this basis, the fate of the delinquent is decided. The appellate authority is to hear the proceeding following the same rules of natural justice. The disciplinary proceeding from the very start is required to be absolutely transparent, fair, just and reasonable, with opportunities granted to delinquent at more than one stage to prove his innocence. Let a reasonable man not think that the result of disciplinary proceeding is pre-decided and the proceeding is an idle formality. In my opinion, there has been a travesty of justice in this case. In this case, the guilt of the petitioner is not established. In its zeal to punish the offender, the management of the bank has given far more publicity to this incident than it deserved. The whole exercise has achieved the opposite of what was sought to be achieved to vindicate the character of a woman. It has subjected the woman concerned to unnecessary curiosity and publicity and the petitioner to ridicule. In those circumstances, the petition was allowed. But I have twofold submission.
Yes.
Not in so far as the propriety of the decision-making process or not the conduct of inquiry is concerned, that was foreclosed.
Then you have to show us the judgment of K.J. Sengupta, his lordship.
Yes, please take page 66.
So your argument that propriety of the inquiry examination was foreclosed in view of this order. So the remand was limited only to a certain extent. Inquiry was not.
Inquiry was not touched.
Yes. Show us the relevant.
Please come to page 68.
Yes.
But the paragraph beginning from the middle portion of that page, Mr. Shengupta, learned senior advocate, appearing in support of this writ petition, contends that there is no observance of principles of natural justice in holding inquiry since beginning, as copies of the documents relied on by the department were not supplied to the petitioner, though demanded. So he could not make out proper defense. The inquiry officer was biased in conducting the inquiry proceedings. This portion of the argument of Mr. Shengupta is not emphasized by him seriously. His serious argument is against the impugned proposed show cause notice. He contends that when the inquiry officer has found his client being not guilty, the disciplinary authority should not have reached and recorded different findings holding his client being guilty behind his back and without serving any notice. In this connection, he relies on two decisions, not that Bank's case. He contends further, attacking the findings of the disciplinary authority, that his conclusion to hold the petitioner guilty is based on no evidence, as he has relied on certain letters of the security personnel who were neither examined nor considered by the inquiry officer. In this context, he relies on two decisions. Next paragraph. He argues further that adjustment of suspension period against the leave, which are lying to the credit of the petitioner, is a punishment which is unheard of under the service rules or even under the service jurisprudence, as the petitioner had undergone suspension period and he had suffered so much so this suspension period could not be treated to be a punishment since it was not imposed so. Adjustment of leave with the suspension period itself is a punishment inflicted upon the petitioner without coming to the conclusion as to whether punishment should be imposed or not, and in fact the same tantamounts to imposition of double jeopardy. Mr. Chaudhary, learned senior advocate, while opposing the writ petition, submits that the writ petition is premature and no injury or prejudice has been caused to him as in compliance of the Honorable Supreme Court decision rendered in Managing Director. Second show cause notice has been issued together with the copy of the report of the inquiry officer and the report of the disciplinary authority who has disagreed with the inquiry officer. He contends that disciplinary authority is well within his right to differ from the findings of the EO. He contends no punishment has been imposed, only tentative punishment has been proposed to be imposed, and the petitioner will have the full opportunity to give reply to the second show cause notice. It may so happen, after considering the representation, the disciplinary authority may change his view. He elaborates while propounding his principle of natural justice, saying, in all cases, observance of principles of natural justice is not called for only in a case when one is prejudiced or injured as to one's right. He relies on 84 Supreme Court. Having heard the respective submissions of the learned lawyers, Mr. Shengupta's contention as against the impugned first charge sheet and also the inquiry proceedings is not acceptable to me in view of the fact that in spite of his grievance of non-compliance of natural justice, his client could participate in the domestic proceedings, and from the records I do not find that his client has suffered any prejudice. He availed of full opportunity afforded by the inquiry officer. Mr. Chaudhary has rightly argued, when no injury or prejudice has been caused, the compliance of natural justice is not a right. Then His Lordship Justice Subhashaji Mukherjee has been pleased to observe in paragraph 41, we must remember again that rules of natural justice are flexible, but I need not trouble your Lordship with that. Then, further, the report of the inquiry officer has not prejudiced the injured petitioner's right, rather he has decided in his favor. So, grievance against the inquiry officer, or for that matter against the inquiry proceedings, are to my mind unfounded. So, I am not inclined to accept the contention of Mr. Shengupta on that score. The inquiry officer admittedly found the writ petitioner not guilty, but disciplinary authority has come to different findings admittedly, without giving any notice or giving any chance of hearing to the writ petitioner before he came to contra findings finally. I am unable to accept submission of Mr. Chaudhary that petitioner is not prejudiced nor injured with the second show cause notice. I hold the petitioner's right has been affected or injured as the disciplinary authority has conclusively come to findings, the petitioner being guilty of the alleged charge and or crystallized by the inquiry officer holding him not guilty, has been taken away. The argument of Mr. Chaudhary would have been appropriate had the inquiry officer held the petitioner guilty, had the disciplinary authority accepted the report as matter of course. The ratio decided by Karunakar's case is not applicable here. I do not find from the language of the second show cause notice the findings of the disciplinary authority is tentative, rather it appears to be a conclusive one, and no scope is open to the writ petitioner to persuade the disciplinary authority to take decisions
Otherwise, as regards fact finding of guilt, very limited scope or opportunity appears to be available to the petitioner as to the nature of punishment to be imposed. It appears from the judgments cited by Mr. Sengupta, Yoginath Bagde, it has been observed by Justice so-and-so in paragraph 53 that before the disciplinary authority disagrees with findings of the inquiry officer who has held him not guilty, it should serve a notice upon the delinquent recording tentative disagreement and give an opportunity to the delinquent that proposed disagreement is not correct on the basis of the materials on record. His Lordship has expounded the theory of tentative decision not conclusive in the disagreement. Similar view has also been taken in PNB. Therefore, I cannot uphold the second show cause notice containing the conclusive findings of the disciplinary authority disagreeing with the inquiry officer. As such, I direct the respondents to treat the said findings of the disciplinary authority as a tentative one, and this should not be treated as final or conclusive, and the proposed punishment should also not be incorporated. Accordingly, I grant liberty to the petitioner to give reply to the second show cause notice, treating the aforesaid findings being tentative. He will be at liberty to place all his case as he has submitted before me. The order adjusting the suspension period against the leave due to the petitioner is set aside. The writ petitioner shall give reply to the second show cause notice within a period of 4 weeks from the date of communication of this order. The petitioner shall be allowed to run his duty. It is submitted by the learned lawyer for the petitioner today that the reply to the aforesaid show cause notice has been filed, so he need not file any further reply. The disciplinary authority will proceed to deal with the aforesaid reply in the light of the observation made by me, and this shall be concluded within a period of 8 weeks from the date of communication of this order. All interim orders stand vacated.
Yes.
Not as it appears, not 3 names featured, not from the order of his lordship, or not from the documents that I have placed so far. One was the victim, Mrs. Chaudhary. The second one was the security agent. And the third one was Mrs. Khan.
The eyewitness.
The eyewitness. Not in a nutshell, not I just submit before your lordship not what the summation of each witness's deposition was. Not Miss Chaudhary, she deposed that she had identified the handwriting of the charge-sheeted employee. Now, these are all on record.
Security agent said.
No, the victim, Mrs. Nupur Chaudhary. Her evidence is at pages 110 to 115 of the paper book. Not I just give in a nutshell, not a brief narrative of what she said or deposed. But she had identified the handwriting. Secondly, that she had given a brief background of her sour relationship with the charge-sheeted employee in relation to a close, proximately close incident a few days or months back. But next comes not the evidence of the security agent. Now this is from page 115 to 124.
Yes.
Not the guard was not produced as a witness because not his evidence was after that incident, the guard was terminated from service. So the security agent's representative had come to depose with the letter.
What letter?
Not the letter of the guard.
Authorized. Yes.
Not, secondly, not he has explained the role and evidence or the duty of the security guards.
Yes.
And thirdly, not he has also explained the movement of 4 persons over the incident. And the third important witness was Mrs. Khan. She was a Group C officer. Her deposition begins at page 125.
Yes.
And she stated that she had seen those 4 persons and one was writing.
But did not name this person.
Yes, name.
He was writing. Yes.
And in fact, this is factual, also borne out from records. During the course of inquiry, the EO had gone to the place of occurrence with the presenting officer and the witnesses.
Writing was still there.
No, not the location, whether it could be visible from that place or not.
Oh.
Where she was standing.
To ascertain the veracity of his statement.
These were the basic or elementary evidence available on record which would constitute quote unquote some evidence available on record as a material for the purpose of arriving at a possible conclusion.
Yes.
The defense witnesses are not in the paper book, so in that can I've enclosed everybody's deposition.
দেখি ওইটা দিন application can application টা দিন আমরা এখন
based on no evidence এই জায়গাটা এভিডেন্স মেইন জায়গাটা আই উইটনেস এই দুটো এভিডেন্স ইয়ে হয়ে যাচ্ছে এই অ্যাকচুয়ালি আইডেন্টিফাই with open eye. Victim identifies the handwriting with open type and type to rope one prior incident with the presenting. Card এটা history.
এসব নো এভিডেন্স কোনখানটা বলেছে
এসব নো এভিডেন্স এটা তো তুলেছি ওরা নিয়েছে Yes, evidence of Mrs. Khan.
But that's also in the paper. For the timing, I don't detain your lordship not with the details of the evidence. The defense evidence are at pages, relevant portions are at pages 99 and 109 of the CAN. 99, 109 and 110. These are the 3 important pages. That's the defense version. Now their version is there were 4 of them and there was another outsider. All 5 on motorcycles went out of the office to meet a particular person. Somewhere at Dharmotara Street, not very far off from that.
Page 99 to 110.
99, 109, 110.
Yes.
Their version was everybody had an appointment with a particular person at Dharmotala Street. So all 5 of them went on 2 motorcycles and therefore they had no knowledge of what incident was there. Normally the office gate on Saturdays closes at 2 p.m. The Royal Street gate. So they were not there. They were playing table tennis till 3 or 3:30 p.m. Thereafter one of them had a wash in the toilet, office toilet. So this is the defense version.
So to support their contention, they were not at the site.
They were not at the site.
Yes.
Stand on your leg first.
Yes. সে তো বলে দিয়েছে আইডেন্টিফাই করে দিয়েছে হ্যাঁ ওর সাথে বন্ধু ছিল যেহেতু ধুলাইটা ঢুকে গেছিল স্টিগম্যাটটা সাফার করে গেছে তো সাফার করে সাফার করো এটা তো খুব বাজে একটা তো হ্যান্ডরাইটিং সেকেন্ডটা হচ্ছে যে খান যে দেখেছে সেই দিন খালি ডাউট ছিল সেই দিন ছুটি ছিল সেদিন ছুটি ছিল এবং ওর সেকশনটা বন্ধ ছিল ওর প্রেজেন্সটা ওখানে এটাই আসলে ওইখানে
Yes.
Sufficiency of the criminal trial. Yes, Mr.
Now, please come to the management's witness first, not whether there was some evidence available on record. Please come to page 111 of the paper book straightway. Triple one.
Not spent on. Yes, page 111.
Yes.
Hard question from the top.
Who is this man who was?
She is Miss
examined?
Chaudhary, Nupur Rai Chaudhary.
Oh, the victim.
Yes.
But NRC means Nupur Rai Chaudhary.
Okay. Say the name, victim. Don't say the name. Yes.
That is in Moscow and other.
Oh.
Who do you think could have perpetrated
Yes.
this act?
The writing is well known to me, particularly the English portion. You can tell us more details as to whose handwriting it was. I think it is most probably Sri Kunal Chatterjee's. Please tell us the reason of your observation. Basically, he is my friend and we were sitting side by side when posted in the account section. So I am well known with his writing, particularly the letter K. Will you be able to write how it was written? I can try. Please make an attempt. Wrote the letter K and the PO produced the writing as an exhibit to the EO. Since this has been given by Mrs. NRC as a specimen K and she has reported that this is most probably the handwriting of Mr. Chatterjee, I will request that it should be verified from the available record, then from the running handwriting where the capital K is coming now and again and not from the signature. Can you tell us from what period to what period you worked together with him? But this goes on. Then after this PO, after this incident took place, did your colleagues come to you to sympathize and condemn this act? Yes, most of them. Did any of the CSCs come? No, none of them.
এটা কি এটা কেন করতে পারলো
এটা মানে পার্টিকুলারলি কে লেখা স্টাইলটা যায়
এর কথাটা এখানে আছে বলে পিকে ঢুকালি আছে
হ্যাঁ
Yes.
Please come to page 113.
The writing was in chalk or any black?
No,
that
it's a paint.
Paint.
Which had to be washed off.
Where do we find that? It was a painting.
It was
All right.
with brush and paint.
Your junior will look into it. Yes, tell us. Yes.
Please come to page 113. I'm sorry, the last question at page 112. Okay.
ঢোকাগুলোর সাথে বন্ধু ছাড়াছাড়ি হয়ে গেল আমার The complaint, Mr. Mujumdar?
That the incident took place on 26th of June. 27th was a holiday, being Sunday. 28th it was deciphered.
28. I think after
it
6
was-
months
No, it was afterwards, my lord. The complaint was, there was a written complaint came
that
forward.
line is, find out that line when was the written. Mr. Mujumdar
the
says it is on 28.
No, that it was deciphered on 28th of June.
This the complaint was leveled much
So
later.
that was later. That is later. Now, that has been explained by the witness, Ms. Chaudhary herself. She initially did not try to fend it off, then things started
No, it will be in the wall of the staircase. Even the managing director will not be aware of these things.
It was on a Saturday. So the first thing on Monday was this.
So when was it?
Deviation.
When was it removed? That also we don't.
But
find.
there was a yes, it was removed. Please come to page 110.
How many days were delay in lodging the complaint?
Not. But I'll just give the date.
Huh?
I'll just give the date. It's in the deposition.
July 1993.
No, the security agent had complained immediately.
Page 146. While replying to a question raised by Priest, why she divulged the fact only on 19th November.
Oh, 19th November 93.
Page 46. জুনের ঘটনা।
হ্যাঁ।
I think we are not hearing you.
Got the something to
favorable কিছু দেখছেন অমনি দাঁড়িয়ে পড়লো।
9 November.
That while replying to the question raised by
Why she was divulging the facts only on 19th November?
No, we want to know, Mr. Mujumdar, was there any written complaint that initiated the proceeding, or on the basis of something else the proceeding was initiated?
There was, as it appears not from the evidence of the security agent,
yes,
that the bank management had contacted the security agency. Why have your guards not taken care of this? So there was an action taken against the guards by the security agent. And the two guards were removed.
Who was that communication of the bank? Was it brought on record?
And this is evidence on record. Please come to page 116. Please come to 116.
That is victim statement.
No, that is security agent statement.
Achha, from victim you have to show anything else? Page 112 you showed us.
And 112, then please come to page 112, the last question.
Yes.
CEO, do you think it has been done by the residents of the staff quarters or outsiders?
It was done. Oh, it's done. I think by resident, because outside may not have any interest.
That was with regard to a different incident. The previous incident. Which would reveal the animosity.
What were the previous incidents?
Please
That
come-
Dhokalia scooter was taken
No,
up.
no, no, please come to 112. How was your relation with them earlier at the top, NRC?
They were friends.
My friends, they were very close to me, particularly Mr. Chatterjee. After the incident, our relation has become very much formal, and they often told that Mr. Dholakia was wicked person and chamcha of management and advised me not to continue any friendship with him. Do you mean to say that your friendship with Mr. Chatterjee and others was as much as that with Mr. Dholakia, and that is exactly what you answered? Yes. Did it appear that they had any grudge against Mr. Dholakia or against you? Not against me, but of course against Dholakia. Please tell us whether all four of them advised you against Mr. Dholakia or some of them, not all. Who were they? Mostly Kunal Chatterjee and sometimes Mr. Dipankar Sen Roy. You have signed a letter dated 6 July 1993 and submitted to the bank. There you have asserted about some incident in the staff quarters. What happened there? I heard a poster against mine and Dholakia's name.
Yes.
26th incident, 27th holiday, 28th security agent contacted, 6th is the written complaint. Please see the penultimate paragraph of that page. Firstly, I wanted to ignore at 112 NRC. Firstly, I wanted
July. 6 July.
Yes.
No,
Complaint was
no,
6 July.
6 July, you have signed a letter on 6 July and submitted to the bank. Where is this letter? This letter has not been exhibited. Then this is totally contradictory to page 44, the finding of the inquiry officer.
No, no, page 44 is something different. Please see what is page 44.
No, page 46,
46.
if you kindly come. Top, while replying to a question raised by PO as to why she was divulging the facts only on 19 November.
When she had identified the writing on 28 June 93 itself,
yes,
she indicated that Sri Chatterjee was one of her close friends and she thought he
patch
would
up the matter.
cross forward and patch up.
So the complaint was on 19th November.
Can't be, because not she had deposed that it was on 6 July.
Then this is a wrong recording.
But there's a disagreement by the discipline authority.
On that point, disagreement. তার অনেক আগে এটা হচ্ছে 29 জুলাই 93 তাহলে কি করে নভেম্বর yes, you take note of that because the charge sheet itself was issued on July 93. Then how can the complaint be of subsequent date? Tally page 46 with page 39.
Letter dated 6 July.
6 July was the letter.
6th July was the date, my lord.
Then 26 incident was on 26, 27th holiday, 28th was this Monday, and 6 July.
6th July, my lord. As when I prepared for myself, I also found that it was
So it is not November.
not November.
And the writ petitioner was suspended on 16th July.
Yes, Anything else, Mr. Mujumdar?
Not only two evidence, not so there was a direct evidence of the victim that she knew the handwriting pattern of the gentleman writing on the wall. Now next comes not the security agent.
Page 115 to 124.
Yes.
Security agent is a security guard. Actually, what
Security guard had not deposed. The security
Yes.
agent had deposed.
So it is hearsay.
But hearsay is.
Yeah, I have heard from security agent.
Not your lordships have
Security
laid,
guard.
not your lordships have laid down way back since 1977 in Banks cases that hearsay evidence is admissible in disciplinary proceedings.
This was a criminal in nature.
But the test
You
of
have to connect with the incident. Connect the
evidence is
incident with the
on getting the complaint from the bank management, the security agent had dispelled with the service of these two security guards.
maybe that who has written you have not properly checked and you are negligent in discharging your duty.
That's right.
And hence you are refusing. But here we are in the inquiry whether it is that this person, none else, committed this
So not
offense.
there was writing.
There was a writing.
Now, not two persons support through corroborative evidence. One says that I know the writing pattern, the other says I saw one of them
To
writing.
my long association and for having experience to work with him. I got the occasion to see his handwriting and signature, and it is known to me.
And the other witness says that I saw them at the landing and one writing.
Where is his Dr. Khan's?
Yes.
Just show us page 115. Any particular question you are showing? 115 to 124 security agent.
But 115, I was showing that under what circumstances the security guards had not been brought as witnesses.
Where is that?
Please come to page 116 straightway.
Yes.
116.
But the witness action, the security agent's witness begins at 115. I refer to page
Yes.
116. Please similar to somewhere the third question maybe with the words KC. We are having some system. POKC, then POKC, then POKC. How do you ensure the total security of the organizations in your charge?
We are having some
system. Our security end after the shift report to us what actually happened, and accordingly we assess the performance of the security guards. What had happened on 26 June 1993 in NABARD, how did you come to know? The day was Saturday and the main door was closed at 2 p.m. Our security guard was feeling little bit uneasy and he was lying on the sofa on the second floor. From there, he found that persons from upstairs going down the stairs. After 30-40 minutes, he personally went down and he saw somebody writing on the wall. He thought that it might be union slogan or something like that and he did not care it. Next Monday, NABARD informed us to come. We came and we found that something was written which was not connected with union matters. Then we started investigating the matter on the basis of requests received from NABARD and we submitted the report to NABARD. Can you tell us the names? The security guard informed us the names of one Mr. K. Chatterjee, Mr. S. Sarkar, one Mr. Viswas, and one Mr. D. Sengupta. Can you give the full names? I do not remember. What was the name of the guard? Rajkishore Sharma. Is he still in our employment? We terminated his service because he failed to report the matter in time. But he was impossible to be, get hold of as a witness.
All right. Yes. And now doctors.
Then please remember the next point. This will probably dispel with the doubt with regard to the date. In your letter dated 6 July 1993, you have indicated that before leaving, your security guard gave the names orally when he gave it in writing. Similar, the security agent had also reported on 6 July.
Yes.
Then let please come to the
কখনো sexual harassment একটা আসেনি বলে না?
না।
কেন বুঝো?
বিশাখা কেস হচ্ছে 15
Yes.
the Dr. Khan's evidence, That evidence is at page 125.
Page 125. আর কত দেখে? Already. হ্যাঁ?
শনিবারে হয়েছে রেসি যাচ্ছে
দুটোর পরে grade 1.
কিছু তো
কিন্তু নামটা করে দিচ্ছে।
একটা হচ্ছে ওর যে হাইলাইটিংটা চেনার কথা ওইটা আমি চিনি আমার পাশাপাশি কাজ করতে এটা জানি। কিন্তু সেটা তো ওই ইয়ে নয়
কোনো লেখার সাথে দেখা
না
না, সেটা কেটা লিখেছিল সেটা রেকর্ড
কি এটা লিখি তাও হচ্ছে পাওয়া যাবে আচ্ছা দেখি কিসে লিখেছে ইয়েস মিস্টার খান একটু দেখি
কোনটা কিসে পেন্টে বলছি।
পেন্টে লেখা হাতের লেখা দুটো
হ্যাঁ
হ্যাঁ it was written on paint and brush. There must be a difference. The victim has seen him to writing on the paper.
No, please see page 125.
125. This is of
Dr. Khan.
Yes.
That pattern might be different by reason of writing on a paper with pen and not user of brush and paint.
Paint on
But
wall.
not if the particular pattern is known, then that is sufficient evidence.
Yes, which one you are showing?
Now, Dr. Khan, please come to the middle portion. Dr. Khan, you are a very highly educated senior Group C officer of the bank. Please answer the questions without hesitation regarding the incident of slanderous and obscene writings on the wall. On what date did you come to know about it? On 26 June 1993. What was the time?
Yes.
At about 4:45 p.m. Where did you see anybody writing something on the wall? Yes, it was between ground floor and the first floor of the front gate, that is on the wall of Royd Street side gate. Do you know at what time the Royd Street gate side closes on Saturdays? At about 2 p.m. Can you tell us the reason as to why you went there at around that time? On that date, I sat a little late. At about 4:45 p.m., I packed up my things and I was going out. I came down by the stairs to the second floor. I was about to take a turn to go to the western side gate. As I reached the second floor, I suddenly heard some voices from the ground floor, that is the Royd Street side gate. Then, thinking that probably the gate is opened, I further proceeded going down. Then at some point, I could see these four, he names all four of them, standing there and busy doing something on the wall. What did you see? I saw Kunal Chatterjee writing the obscene graffiti. Anything else? Dipankar Shenroy was dictating him, and Oshim and Shamol Jyotish Sarkar were standing behind them and fully absorbed in watching what was going on. When you first saw, how much portion of the writing was over? Up to PK, it was over. Up to PK Dholakia. And he says, it was written in English and all block letters. When you first saw them,
No, madam, we are proceeding on the presumption that whatever was written, it was almost on the verge of completion.
we want to say that yes. She says yes. Not I have not read out the portion from the charge sheet. Now please come back to the charges at page 39.
We say yes. Consistency inherent.
But she says that it was written in black ink with the use of brush.
It was written with a small brush.
And she had complained on 5th or 6th of July on the next page. Please see not somewhere in the middle portion. PO, you have submitted a letter to the bank which is dated 5th July 1993. Can you tell us the reason as to why you took a few days time to write to the bank? First few days I was on leave and then I proceeded on tour. When I came
Page
back.
127.
127.
Yes, yes.
Just after the middle portion.
Yes, yes.
I was on tour and then I came back. When I came back, I found some changes in the office. So I thought probably the guilty would come forward and patch up the matters. So I was waiting for it. When ultimately I saw nothing coming up, I made up my mind to inform the bank. Do you stand by the words of your letter? Absolutely. When did you write the letter? 5th or 6th of July. When did you witness the incident? She again reiterates. Then not the question was, why was she staying back that late? Not she says that I have often worked till 7 o'clock in the night in the office. So considering my late stay in the office, it was not to be treated as abnormal.
All right. So you summarize your argument. Anything else you
Now,
want?
these are the not apropos. ঢোলাকিয়াটা দেখে দিন না ঢোলাকিয়াটা কেন গেল 95 কেন দাগ দিয়েছিলাম ও আচ্ছা ডিফেন্স Now, please come to page 86 of the can. Now, that is the evidence of Mr. Dholakia. It begins at 85. But why this suddenly flared up?
I see the back of the shade of the baby.
বসে থাকবে যে কি হয়েছে ওরা এই জিনিসটি অ্যাপোলোজাইজ করবে অ্যাপোলোজাইজ করবে মানে তো
Question can be to remain one case then at least by it does it can be more late.
You have already said that I was going down. It was, but when I saw the option, I did not want to proceed further. I did not. Yes.
Yeah. Please come to not page 85, not middle portion of that page. Not it's just not there. There is a left hand. There is a marginal signature on the left hand side margin at page 85 of the can. I'm sorry.
Can it?
There is a signature in Hindi on the left hand side margin. Left hand margin.
Yes.
Alongside that first letter, there is a question put by the PO. Page 85.
85.
85 of the can.
Yes.
But the Hindi signature on the left hand margin not begins with a word. Not, there is a PO.
What is the question?
After such an incident, it is normal that people will sympathize. Did the people come to you?
This is whose evidence?
Mr. Dholakia.
Oh, Dholakia.
Practically one and all came to me and sympathized me. Any of the CSEs came to you? No, none of them. But when your lordships not are considering not the impact of the oral evidence, But your lordships will also have to take into consideration the immediate human behavioral approach post the incident or conduct. All in the office came to discuss, but for these four. And that's not only that had happened not only with Mr. Dholakia, but also with Mr. Chaudhary.
Even with the Dr. Khan.
No, with Miss Chaudhary. Dr. Khan went on, she had a leave, she went on tour for 2 days, came back, found things in the office had changed, therefore she made a written complaint on 5th or 6th of July. Practically one and all came to me and sympathized me. Any of the CSEs came to you? No, none of them. Do you have any
Reason to believe
that anybody in this office has got a grudge against you? I have plenty of reasons to believe that some persons in the office bore grudge against me because there were some incidents immediately preceding this wall writing which showed that some people wanted to harm me. This inquiry is being conducted to unearth the truth. So please tell the EO the incidents one by one which you have inferred it. First incident about a fortnight before the incident was that one security guard who on DGM's instructions was removed for administrative reasons, later on went to my friend's house and told something against me, and I saw these people going around and sitting in front of almost all, telling them that I was involved in removing that security guard and that I want to settle some type of personal score with that guard. Second incident is that on the Saturday before 26 June 1993, when I went down in the afternoon after the office closed to take my scooter parked in the basement, I found that somebody had torn off my front seat cover of the scooter apparently with a blade. Third, a couple of days before this wall writing incident, there was a poster pasted inside the lift cabin of block B2 where I reside, once again linking my name with the same lady. When the security guard incident was a fact, they have often come near my table without any apparent reason and talk in sufficiently loud voice to tell that Mr. Dholakia had a godfather here in the form of Mr. C.M. Kamdar, and that after he has gone, he has to face the consequences now. When this threatening was given, some days before the incident of wall writing, all these four people were involved, mostly by D. Sen Roy. You have mentioned about a poster in RNC Road quarters. Please tell us some details about it. Some 5 to 6 days before this wall writing incident, one day morning at about 7 hours, Mr. N.S. Yadav, ADO, who also resides in the same complex, came to my flat to take back the camera I borrowed from him earlier. After about 5 minutes or so, when I went out to see him off at the lift gate, both of us found the lift door open and we saw the poster inside pasted apparently with the gum on the four corners of the wall, facing the entry saying JKE 5540, then the name, then Dholakia. N.S. Yadav later on told me that when he was coming to my flat, he had requisitioned the lift from the ground floor and heard the buzzer indicating that the lift was stuck up at one of the upper floors. That is how it happened. JKE 5540, what was that? That is the registration number of my scooter purchased in Jammu and Kashmir. What did you do after saying it? I discussed with Mr. Yadav and treated it with contempt it deserved and ignored it.
Oh. All right. Yes.
Please similar the second question on the next page. Page 87.
Yes.
Any of the CSEs reside in the quarters? Mr. S.J. Sarkar, Sri K. Chatterjee and Sri D. Sen Roy are staying in the same complex, and incidentally, Sri D. Sen Roy stays in the same floor where I stay. After this incident, did you notice any perceivable change in their behavior? Even after the incident, I could often see particularly Mr. D. Sen Roy walking and passing me on the third floor where I sit with some kind of smug smile on himself, satisfied and joyous of having done damage to me and my name. Anything else regarding any other of the CSEs? Yes, again after some days, I do not exactly remember the day, possibly on 24th August, when at about 3 p.m. when I was going to Alipur in connection with some office work, myself being so and so 24 August, when I was going to take a scooter, I found Mr. Chatterjee and Mr. Sarkar standing nearby, and on seeing Mr. Chatterjee called out an abusive word at me. What was that? Dholakia mentions the word which is unprintable. Let us not go, but there was a chain of events which is not too far off. The proximity of the incidents commencing.
Yes.
Not apropos that particular incident which happened on 27th of June 1993, 26th of June 1993. This may not have a direct bearing, but not this have a weightage insofar as circumstantial evidence is concerned. The immediately past incidents having a nexus, having a possible nexus, if I may put it in this way.
Yes.
Not coupled with not the behavioral approach of these gentlemen post the incident in the office.
Yes.
It's not a proof of reasonable doubt. It's a proof of preponderance of probabilities.
Any judgments here?
Three judgments.
Yes, come.
ওটা কি দরকার? ও নিজেই ডাইরেক্ট করেছে ওটা কেন না? Now 98.7 টা দাও আগে। কপি আছে? Please come to paragraph 15 of that report at page 93. 1998, 7 SCC,
15
84.
1-5.
Paragraph 15. Opinion, copy. 98, 7, 84. At paragraph 15, page 93.
Yes.
Not this judgment is a proposition for returning a tentative finding on disagreement, but not I rely on some portions of this judgment only to show not when it relied upon previous judgments, not it had laid down not what should be the test. Please come to the quoted portion at paragraph 15. Not it is quoting from Karunakar. We ought, however, to add that if the dismissing authority differs from the findings recorded in the inquiry report, it is necessary that its provisional conclusions in that behalf should be specified in the second notice. It may be that the report makes findings in favor of the delinquent officer, but the dismissing authority disagrees with the said findings and proceeds to issue the notice under Article 311(2). In such a case, it would obviously be necessary that the dismissing authority should expressly state that it differs from the findings recorded in the inquiry report and then indicate the nature of the action proposed to be taken against the delinquent officer. Without such an express statement in the notice, it would be impossible to issue the notice at all. There may also be cases in which the inquiry report may make findings in favor of the delinquent officer on some issues and against him on some other issues. That is precisely what had happened in the present case. If the dismissing authority accepts all the said findings in their entirety, it is another matter. But if the dismissing authority accepts the findings recorded against the delinquent officer and differs from some or all of those recorded in his favor, and proceeds to specify the nature of the action proposed to be taken on its own conclusions, it would be necessary that the said conclusions should be briefly indicated in the notice. Let I pause here for a moment. But his lordship returned a finding that the second disciplinary authority sat in appeal over the findings of the first disciplinary authority. That's why this is not opposite to the law laid down by the Honorable Supreme Court.
No, this when the difference arose, no hearing was given. That is why he came to this court.
Yes.
Court said that you
Treat this as tentative. With the observation that very well you are not prejudiced, therefore no violation of natural justice. But at the same time, there was an observation that you can argue whatever is argued before this honorable court in reply. But there is a specific observation on
acted as an appellate authority.
Yes.
So what would have an appellate authority done in such circumstances?
The appellate authority's jurisdiction was not at all sparking off at that stage. Not as his lordship rightly held, the duty of an inquiry officer is to collect materials. Not there are umpteenth number of cases your lordships have come across where the inquiry officer only collects the evidence, does not file a report. He only collects the evidence and places it before the disciplinary authority. And differs from some or all of those recorded in his favor, and proceeds to specify the nature of the action proposed to be taken on its own conclusions, it would be necessary that the said conclusions should be briefly indicated in the notice. So if the disciplinary authority, which has been described as the second disciplinary authority on remand, has done so, where could be the question of such disciplinary authority exercising appellate jurisdiction over the first disciplinary authority's order? In this category of cases, the action proposed to be taken would be based not only on the findings recorded against the delinquent officer in the inquiry report, but also on the view of the dismissing authority that the other charges not held proved by the inquiry officer are, according to the dismissing authority, proved. In order to give the delinquent officer a reasonable opportunity to show cause under Article 311(2), it is essential that the conclusions provisionally reached by the dismissing authority must, in such cases, be specified in the notice, but where the dismissing authority purports to proceed to issue the notice against the delinquent officer after accepting the inquiry report in its entirety, it cannot be said that it is essential that the dismissing authority must say that it has so accepted the report. As we have already indicated, it is desirable that even in such cases, a statement to that effect should be made. But we do not think that the words used in Article 311(2) does not apply in our case. So I need not trouble your lordship with 311. Then please see paragraph 16. Not in the given facts, I need not trouble your lordship with paragraph 16 because the court had ultimately remanded the matter. Please come to the next page.
Yes.
Just in the line beginning against placitum F, the sentence begins from the middle portion of the line with the words, if the inquiry officer.
Yes, no. This is page 96.
95. Against placitum F, if the inquiry officer were only to record the evidence and forward the same to the disciplinary authority, that would not constitute an additional material before the disciplinary authority of which the delinquent employee has no knowledge. However, when the inquiry officer goes further and records his findings as stated above, which may or may not be based on the evidence on record or are contrary to the same or in ignorance of it, such findings are an additional material unknown to the employee but are taken into consideration by the disciplinary authority while arriving at its conclusions. Both the dictates of the reasonable opportunity as well as the principles of natural justice therefore require that before the disciplinary authority comes to its own conclusions, the delinquent employee should have an opportunity to reply to the inquiry officer's findings. So there was no question of the disciplinary authority having acted as an appellate authority when the reply to the inquiry, the disagreement was being considered.
Yes.
Now, my lord, please take note 2020.
দেখে তুমি whole case
21 to SSC to the
based on no evidence, never evidence দেখো এসব কি করে একটা ঠিক হয়নি এ করলো কি ডিসপ্লিনারি কি করলো কি যে যে পয়েন্ট গুলো দিয়েছিল সেগুলো কাটতে চাইছে
Yes, 2021 to SSC 612
জাস্টিফাই করতে ওই জন্য উনি কথাটা
No. But please come to paragraph 24. At 626. It is the, have your lordships got that? Paragraph 24 at 626. It is thus settled that the power of judicial review of the constitutional courts is an evaluation of the decision-making process and not the merits of the decision itself. It is to ensure fairness in treatment and not to ensure fairness of conclusion. The court or tribunal may interfere in the proceedings held against the delinquent if it is, in any manner, inconsistent with the rules of natural justice or in violation of the statutory rules prescribing the mode of inquiry, or where the conclusion or finding reached by the disciplinary authority is based on no evidence. If the conclusion or finding be such as no reasonable person would have ever reached, or where the conclusions upon consideration of the evidence reached by the disciplinary authority are perverse or suffer from patent error on the face of the record, or based on no evidence at all, a writ of certiorari could be issued. To sum up, the scope of judicial review cannot be extended to the examination of correctness or reasonableness of a decision of authority as a matter of fact. When the disciplinary authority is inquiry is conducted for the alleged misconduct against the public servant, the court is to examine and determine: 1. Whether the inquiry was held by the competent authority. 2. Whether rules of natural justice are complied with. 3. Whether the findings or conclusions are based on some evidence and authority has power and jurisdiction to reach finding of fact or conclusion. It is well settled that where the inquiry officer is not the disciplinary authority, on receiving the report of inquiry, the disciplinary authority may or may not agree with the findings recorded by the former. In case of disagreement, the disciplinary authority has to record the reasons for disagreement, and after affording an opportunity of hearing to the delinquent, may record his own findings if the evidence available on record be sufficient for such exercise, or else to remit the case to the inquiry officer for further inquiry. It is true that strict rules of evidence are not applicable to departmental inquiry proceedings. However, the only requirement of law is that the allegation against the delinquent must be established by such evidence, acting upon which a reasonable person acting reasonably and with objectivity may arrive at a finding upholding the gravity of the charge against the delinquent employee. It is true that mere conjecture or surmises cannot sustain the finding of guilt even in the departmental proceedings. The Constitutional Court, while exercising its jurisdiction of judicial review under 226 or 136, would not interfere with the findings of fact arrived at in the departmental inquiry proceedings, except in a case of malafide or perversity, that is, where there is no evidence to support a finding, or where a finding is such that no man acting reasonably and with objectivity could have arrived at those findings, and so long as there is some evidence to support the conclusion arrived at by the departmental authority, the same has to be sustained. So the observation is in favor of sustenance and not in favor of interference. The test being one of availability of some evidence. Now, disagreement is not perversity.
One view may differ from the other, but if one view is possible, then that is not a test of perversity. Now, there were persons who had come before the inquiry proceeding and deposed that there was some acrimony over an incident or over a series of incidents which was in close proximity to the one complained of.
Yes.
Secondly, deposition of an eyewitness.
Yes, you have referred to that, Mr.
Thirdly, identification of a handwriting pattern. And fourthly, not the conduct after the incident took place.
Yes, we have taken note of that.
Now, the last judgment, 2021 11 SCC 321.
Para?
Para 20. A three-judge bench of this court in state of Haryana versus Ratan Singh was dealing with a case of non-examination of passengers when the allegation against the conductor was non-issuance of the tickets. This court held that in a domestic inquiry, strict and sophisticated rules of evidence under the Indian Evidence Act may not apply, and that all materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence provided it has reasonable nexus and credibility. This court held as under. It is well settled that in a domestic inquiry, the strict and sophisticated rules of evidence under the Indian Evidence Act may not apply. All materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence provided it has reasonable nexus and credibility. It is true that departmental authorities and administrative tribunals must be careful in evaluating such material and should not glibly swallow what is strictly speaking not relevant under the Indian Evidence Act. For this proposition, it is not necessary to cite decisions or textbooks. Although we have been taken through case law and other authorities by counsel on both sides, the essence of a judicial approach is objectivity, exclusion of extraneous materials or considerations, and observance of rules of natural justice. Of course, fair play is the basis, and if perversity or arbitrariness, bias or surrender of independence of judgment vitiate the conclusions reached, such finding, even though of a domestic tribunal, cannot be held good. However, the courts below misdirected themselves perhaps in insisting that passengers who had come in and gone out should be chased and brought before the tribunal before a valid finding could be recorded. The residuum rule to which counsel for the respondent referred, based upon certain passages from American jurisprudence, does not go to what extent, nor does the passage from Halsbury insist on such rigid requirement. The simple point is, was there some evidence or there was no evidence? Not in the sense of the technical rules governing regular court proceedings, but in a fair common sense way, as men of understanding and worldly wisdom will accept. Viewed in this way, sufficiency of evidence in proof of the finding by a domestic tribunal is beyond scrutiny. Absence of any evidence in support of a finding is certainly available for the court to look into, because it amounts to an error of law apparent on the record. Then what Gunasekharan is quoted. Please come to the next page. Not that I have quoted that. Please come to D. The authorities have disabled themselves from reaching a fair conclusion by some considerations extraneous to the evidence and merits of the case. The authorities have allowed themselves to be influenced by irrelevant or extraneous considerations. The conclusion on the very face of it is so wholly arbitrary and capricious that no reasonable person could ever have arrived at such conclusion. The disciplinary authority had erroneously failed to admit the admissible and material evidence. The disciplinary authority had erroneously admitted inadmissible evidence which influenced the finding. The finding of fact is based on no evidence. Under Article 226, High Court shall not, then the caution, reappreciate the evidence, interfere with the conclusions in the inquiry in case the same has been conducted in accordance with law, go into the adequacy of the evidence, go into the reliability of the evidence. Now, this is very important in the facts of our case. Interfere if there be some legal evidence on which findings can be based. Correct the error of fact, however grave it may appear to be. Go into the proportionality of punishment unless it shocks its conscience. Not there, the suspension period was only for 1 year, 93 to 94. In another judgment, BC Chaturvedi, I need not trouble your lordship, this is quoted once again. Please come to paragraph 24 straightway. But where Ajit Kumar Nag is quoted. I'm sorry, this court in Ajit Kumar Nag versus IOCL held that the degree of proof which is necessary to order a conviction is different from the degree of proof.
This is well said.
Well said. But that last within course preponderance of probability.
Yes.
And where the last paragraph of that judgment is touchstone of reasonableness. Please come to paragraph 25.
Yes.
But against placitum E and F, the purpose of domestic inquiry is explained, and the purpose of criminal proceedings is explained. These are.
Thank you. Yes.
And not considering the.
Yes. Yes, Mr. Bhattacharya.
And only one submission. His lordship had also commented on the propriety of the order of the appellate authority. It is unreasoned one. Being devoid of reason, the appellate authority's order was also commented upon. Comrade, kindly recollect S.N. Mukherjee, 1990 Supreme Court, paragraph 43. 36. And paragraph 36 is at page 612 of that web edition. Reasons, when recorded by an administrative authority in an order passed by it while exercising quasi-judicial functions, would no doubt facilitate the exercise of its jurisdiction by the appellate or supervisory authority. But the other considerations referred to above, which have also weighed with this court in holding that an administrative authority must record reasons for its decision, are of no less significance. These considerations show that the recording of reasons by an administrative authority serves a salutary purpose, namely, it excludes chances of arbitrariness and ensures a degree of fairness in the process of decision making. But here the disciplinary authority's order is not unreasoned. The said purpose would apply equally to all decisions, and its application cannot be confined to decisions which are subject to appeal, revision, or judicial review. In our opinion, therefore, the requirement that reasons be recorded should govern the decisions of an administrative authority exercising quasi-judicial functions, irrespective of the fact whether the decision is subject to appeal, revision, or judicial review. It may, however, be added that it is not required that the reasons should be as elaborate as in the decision of a court of law. The extent and nature of the reasons would depend on particular facts and circumstances. What is necessary is that the reasons are clear and explicit so as to indicate that the authority has given due consideration to the points in controversy. The need for recording of reasons is greater in a case where the order is passed at the original stage. The appellate or revisional authority, if it affirms such an order, need not give separate reasons if the appellate or revisional authority agrees with the reasons contained in the order under challenge.
Yes. Yes, Mr. Bhattacharya. Yes.
My lord, I first proceed with the order of suspension. My lord, the order of suspension, this was issued on 16/7/1993 at page 41.
Yes.
Now, my lord, kindly take the pinch, my lord.
Page 41.
41. Sri Kunal Chatterjee, clerk, is attached to project and operation department, is placed under suspension with effect from the close of the business on 16 July 1993 in terms of Rule 47(5) of the National Bank for Agricultural and Rural Development Staff Rules 1982. During the period of suspension, he will receive the subsistence allowance as provided in Rule 47(3). During the period of suspension, Sri Kunal Chatterjee shall not enter into any of the bank's premises unless advised to do so except by the bank. Further, he shall also not leave the headquarters except with. Now, my lord, the very significant feature of the matter that I should place before my lords is the charge sheet dated 29/7/1993, that is at page 39 and 40. This is very relevant. The wordings are also very relevant.
Yes.
You are hereby advised, Miller, this kindly note that this charge sheet was issued on 29 July 1993. You are hereby advised that in the circumstances stated in paragraph 2 below, on the charges as set out in paragraph 3 have been framed against you. You have written abusive, indecent, obscene, and disparaging remarks against
Such and such.
such and such. Group 1, a lady employee of our bank, amounting to her character and assassination and causing indignity to her on the wall adjacent to the staircase between ground floor and first floor 8 step to 12-14 stock when counted from below at about 16:45 hours on 26/6/1993. As the Lordship was indicating that also. The exact writing in Bengali, I need not, my lord, repeat this particular provision. Yes. Nupur Chaudhary, the such and such is available. I need not, my lord, use this language.
Archer, you have.
Yes. Further, you had also made disparaging and derogatory remarks against Sri K.P. Dholakia, development officer, in the above writing, which accounted to her character assassination. Now, indulging in the above acts, you have tarnished the image of the National Bank and created an unhealthy atmosphere in the bank's premises. You are therefore charged with having committed an act of serious misconduct within the meaning of Rule 47(1) of NABARD Staff Rules 1962 and acted in a manner which is unbecoming of an employee of National Bank. The charge sheet is accordingly issued to you under Rule 47 of the NABARD Staff Rules 1982. The documents in possession with the bank in support of you above charges are as under. Letter document from the Security Services of India, the agency entrusted with the job of providing security of the bank's premises, indicating your involvement along with other acts in the acts of the writing on the wall. A letter from the staff member having seen you in the act of writing on the wall on 26 June 1993. Certified document giving evidence of exact words written by you on the wall. You are hereby called upon to answer the above charges in writing within 10 days from the date of receipt of the charge sheet. Any evidence which you may wish to produce should be submitted along with your reply to the above charges. Now, my lord, Now, Millard, I just indicate to my lords, Millard, about the facts of the case.
No, that we have.
I just know what I want to say. That, Millard, first of all, kindly see the most important part of the matter which I want to indicate before my lords, that whether this particular LS charge which has been brought against me, Millard, ডিউটি করা আমার তো ফালতু the misconduct, my lords, is well about, my lord, about the factum of listed misconduct, enumerated misconduct, and unenumerated misconduct.
That was not a ground taken by you.
No, I say that. I indicate that.
Question, Mr. Mojumdar, that
Yes.
break-in service.
Yes, your lordship was indicating at the very, I was.
That point, we were asking him, but that is not the issue here. You have not taken that point that they are imposing a punishment which does not stand pegged with the charge sheet.
Which it does not
stands pegged with the charge sheet. The
Yes.
charge was as regards this disparaging remark.
Yes.
Charge was disparaging remark for which a punishment has been given.
Yes.
Punishment is this reduction of pay along with break-in service for calculating gratuity.
Yes. Now your lordship has to, my lord, come to a conclusion as to whether.
Now, Mr. Bhattacharya, what is your argument to that effect that there was no evidence?
That's the thing I am showing to my lord.
Yes.
That's the thing which I am coming. Now, my lord, kindly see the inquiry officer. He submitted a report on 12th of April to 1994 at page 43 to 48. Now,
Yes.
I say, my lord, I specifically, my lord, take this point that there is no definite and conclusive evidence that the petitioner had written the same in the inquiry report. In the inquiry report, which my lords had taken note of at page 43, my lord, I need to, my lord, place before my lords this inquiry report, because this is the sheet anchor of my case.
You may take us to the relevant portion.
That I will do. That I will. Obviously, whole Millard, that will be just wasting the time of the court. Millard, just permit me.
Yes.
Just 1 second, Millard. Yes. Kindly come from page 45. I'm grateful to my lords.
Yes.
With this, I proceed to examine the evidence and exhibit placed before us during the inquiry, and also consider as to whether the charges framed against the charge sheeted employee have been established or not. The PO submitted a list of witnesses to the inquiry officer, and as many as 9 witnesses were examined on different dates during the course of the oral inquiry. The first 3 witnesses, namely Sri M. Roy, caretaker, Sri Chanda ADO, and Sri D.K. Mahanti, deputy manager, will testify during the oral inquiry that they had seen the wall writing on 28 June 1990. And all of them expressed the view that it had been done by the bank's own staff. It was also brought out by the PO during the oral inquiry that there was a strong feeling among the employees of the bank against such heinous act of writing filthy comments involving the staff of the bank. In the deposition of Srimati B. Basu Clark, Group 1, the same point was brought, and it must have been the handiwork of some insiders. But both Srimati Basu and Sri Talukdar had also highlighted the strong feeling, particularly among as the lady employees against such writing, defaming one of the lady
Staff of the bank.
lady staff of the bank. The P also produced copy of the joint representation of the bank. From the depositions of PW1, it was brought out that the incident had happened and there was a strong demand to bring the culprits to book. On an analysis of the evidence given by Sri M. Roy Chaudhuri Clark, Sri P.K. Dholakia, Development Officer, the accusing fingers were pointed onwards. The charge-sheeted employee mainly on the ground that none of them had approached the employees to express their sympathy. In a deposition of MW6 also stated that this letter K as written on the wall was most probably the handwriting of Sri Kunal Chatterjee. In a deposition, Milord, there, kindly see one thing. Your Lordship is well aware of, Milord, I need not. The language shows that probably, and also in other places also I found this word probably was there. Now, Milord, probably.
Where?
Now, Milord, when they form an opinion, I'm grateful to my Lord. Milord, my Lords have laid down the law that suspicion cannot be equated with the proof of guilt. This is well settled.
This was in your favor. The inquiry order was in your favor.
I say, why I say, because I have to, Milord,
there was no definite. What is your argument to that? You are meaning to say that the PO, the inquiry report was banking on suspicious observation?
No, I submit to my lords that
there was no definite
the inquiry report. There is nothing which shows that the respondent writ petitioner's charges had been established.
What more is required, Mr. Bhattacharya?
Milord, I say, Milord,
9 witnesses examined.
Yes.
It is not a case of no evidence.
So I say, Milord, your Lordship has also to, because in a situation of this nature, your Lordship has to examine.
No, there is no counter case that there was any attempt to victimize the person.
Milord, I submit to my lords
in
that
an office, if a statement is made, you are right. You are right on the other that suspicion cannot be construed to be a proof of an incident. But the holistic matter, justice, if you take a holistic view, somebody writes something in the wall. Now, there is an eyewitness subject to objection that may be taken by whether it proves or not. But the thing is that what is the aftermath? Aftermath is if I have done something wrong, I cannot say I apologize because that.
What I would be indicating, your Lordship was looking into the evidences. What I find, Milord, from the particular.
You cannot reappreciate the evidence. That is well settled.
Yes.
That has been an empty argument.
Yes.
He has tried to show us the deficiencies in the evidences. Yes, you.
Right. Now, Milord, I submit to my lords. Kindly come to the last page, which I was showing, page 47.
Yes.
In the Milord, I say, Milord, at the risk of repetition, I say that this particular report of the inquiry, for my satisfaction, is required to be placed. But even then, Milord, for the paucity of time, I say, Milord, at page 47,
কিন্তু সেটা লিখিত নয়, দেওয়া দেওয়া এখানে ইনসিডেন্টটা হচ্ছে যে পর এটা ডিটেক্টেড এখান থেকে যে কিছুদিন আগে এটা নিশ্চয়ই ভেতরের লোক এবং এদের সঙ্গে একটা যে আসছে সেটা বোঝা
একটু দয়া করে একটু
6 তারিখে চিঠি আসে সিগারেটে সিকিউরিটি 6 তারিখে আবার ভিকটিমেরও চিঠি অন দিস বেসিসে হবে এবং যখন উইটনেস দেখলো তখন কোনো হিউম্যান ক্রাইম পরবর্তী ক্ষেত্রে তাই না ছুটি নিতে পারে ও কিন্তু বললো না ফোন করে যেগুলো স্বাভাবিক ইনসিডেন্টটা মানে ছুটি কিন্তু মেবি
The thing which I wanted to place before my lords at page 47 in the last paragraph, that in the light of the foregoing, it can be conclusively indicated that the charges framed against Sri Kunal Chatterjee of having perpetrated the act of wall writing, the indecent graffiti, have not been established. This is number one. Then the second page.
Where did you read? Page 47.
Page 47, the last paragraph.
In the light of the
Yes. That is the conclusion drawn.
Yes. And then page 48. Similarly, the charges framed against the other three charge-sheeted employees, namely Sri Asim Bishwas, Shamol Jyoti Sarkar and Dipankar Shin Roy, of having abetted the act of wall writing, have also not been established.
Where is your written statement, Mr. Bhattacharya? That is not annexed to the paper book. Annexed?
দেখা দেখা
আমি তো পাইনি। You have annexed the statutory appeal, but where is your written statement to the charge sheet?
চার্জশিট দিয়েছিস, চার্জশিট dated 29 July.
If you don't annex it, you can show us the letter which was given in terms of the order of the Justice K.J. Sengupta. That
yes, that order is page.
That letter was also
that is page.
Can assist us.
That
is we want to know your stand.
Yes, my stand.
What is your stand? যে I was wrongly implicated.
I'm grateful to my lords. I'm grateful to my lords.
Due to previous grudge or anything like that.
ইসনি জসাব এটা দেখে বলছে যে চার্জশিটের রিপ্লাই দেওয়া তোর কাছে আছে কি এখানে সেটা কি আছে সেটাও জানিস না My lord, so far as my instruction
Page
is
77 is the order of the second order of the. Is it 77? No, that is 8th May.
That's after remand. After remand, the final order of the competent authority.
8th May 2000.
Yes, that's 77.
Deal করেছে
The reply to the charge sheet subject to correction is not on record. It's not.
Contradictory to each other. So,
the reply of the charge sheet is not on record. I think I did not find it.
There is a difference between name of security guard and letter written by the security.
সেটা তো ওকে দিয়ে
Match material variance of the identity of one person.
সেটা তো অ্যাডমিটেড কেন ওকে টার্মিনেট করে দিয়েছে
না সেখানে আমার নামে গন্ডগোল বুঝেছি
Yes, Mr. Bhattacharya. That contention we find at page 78.
Page 78. Final order of the competent.
Yeah, good order. Second order is ওইটা একটা পয়েন্ট কাটার চেষ্টা করেছে যেটা তুমি করছিলে as regards the confusions created by the name of the guard and about the name এই যে কনফিউশনটা ক্রিয়েট হয়েছে সেটাকেও ডিসকার্ড করিয়ে দিচ্ছে একটা রিজন
ও বলছে মানে প্রসিকিউশনের ল্যাকিংটাকে ফিল আপ করতে যাচ্ছে Yes, আর কি চারটে ষোলো কনফিউটেড হয়ে গেছে Yes, we shall.
Now,
factual issue, Mr. Bhattacharya, you need not deal. You
No,
can
I will
summarize
not.
your argument
Yes.
that these are your points. And
I will not go into the same issues which have been.
yes, yes. So you can just summarize your argument as
Yes.
to what had
Yes.
been the.
Now, Milord, one of my principal submissions will be that in a matter, in a disciplinary proceeding matter, whatever is the evidence that is on record, now interpretation of the particular evidences which have been adduced by parties, this is not permissible.
বলছি যে হাইকোর্ট জুডিশিয়াল রিভিউতে আবার রিইন্টারপ্রেট করবে করে in exercise of judicial review we cannot do it.
It is well settled, my lord. My lord is more aware of it than me. Then, my lord, my next submission is the order of 21st of May 1994 that my lords will be pleased to find
Yes,
From
77.
yes, from page 4950.
No, page 77.
Oh, 70. Yes, 77 is the, I'm sorry, Miller. The
Order of the disciplinary
yes,
authority
yes,
upon
yes.
remand. Yes, what you are saying?
I am submitting one thing that Miller, the competent authority passed this order on 21/5/1994.
On 8th May 2001. Page 77.
No, I just subject to correction of my lords Miller. Kindly see for a second, Miller, page 49.
Page
Page 49, yes. This I
That is
think
the
was
first order.
yes. This was not possibly it was not drawn to the kind attention of the court. This was dated 21st of May 1994. Here, Miller, your lordship will be pleased to find that there is no definite evidence as to how the alleged charges are established.
No, this is the second show cause. Kindly to the bottom of the, you are therefore advised to show cause as to why the proposed penalty shall not be imposed.
Yes.
Second show cause, at that juncture you went to court.
Court.
Court said that no, you have to give a hearing. Direction Justice Sengupta disposed of the matter.
Now, after the order of
Justice Sengupta, page 77 came.
yes. Then my lord Miller was pleased to indicate Miller about the final order of the competent authority. Now, your lordship may kindly consider that an appeal was filed before the competent authority on 14th of September 2011.
Yes.
2001, I'm sorry. This is a page 84 to 106.
Appellate authority order.
Yes. Page 84 to 106.
Yes. What you are adding to that?
My lord, I submit to my lords that in the appeal filed before the competent authority, it was contended that Dr. Mrs. A.B. Khan did not allege about the incident to anybody, not even by writing a letter and a memo of protest. Kindly see, my lord, this I am showing to my lords, page 84.
She wrote a letter.
No, what I found, my lord, this is on record.
Page 84 show us.
Page 84. Kindly see.
This is the appeal which you preferred.
Yes. Appeal against the order and finding of the Deputy General Manager.
Now, which page are you showing?
I am showing to my lords from page 84. This has also been typed. Now,
grounds are at page 86.
Yes.
One was several witnesses among claimed to be an eyewitness.
Kindly see these paragraphs, only 4-5 paragraphs. From paragraphs, this is very illegible, Miller, but from এটা কত পাতা এসে একটু দেখতে হয়েছে না, আমি তো এখানে কিছুই পড়তে পারছি না। পেজ 105-এর এইখান থেকে কত নম্বর প্যারাগ্রাফ এটাও জানিস না তো? পেজ 105, paragraphs H, I, J, it is actually at page 105 Lord, kindly condone my
Which paragraph you are
page 105 to 106. Kindly for a second, my lord, kindly see what were, my lord, the
finding. The
yes,
finding.
Yes. Kindly see this. This is very relevant.
Page 105.
Page 105 to
106.
106.
In cross-examination of it, PO never suggested or attempted to suggest they were giving false evidence. Otherwise, interested. In fact, these three witnesses were absolutely unbiased and unfiltered, independent witnesses. They excluded for the old favorite. Did not at all address himself the material part of the evidence of it. Just picked up certain portions. Manner in which it shows the bias. What is page 105? This is
Page
maybe your
105 is a continuation, Millard. I was also trying to ascertain it. Millard, this is a continuation of, Millard, just a second, I appeal to my lords, Millard.
Appeal, my lord, that the appeal before the appellate authority. That's his
Which
appeal.
he filed.
Yes.
These are your grounds of challenge.
Yes.
105 and 106.
Yes. Your lordship wanted to know that
What are your...
were, yes.
Very good.
Then, my lord, one thing I should indicate to my lords, my lord, that there is no element of contradiction in the deposition of DW 234. Because if I say anything, my lord, that will not be accepted by the court. I have to say something.
DW 234. 234.
Yes, 234.
That is the persons who were with the delinquent.
Yes. Now, my lord, then the point is that the findings of the competent authority in the order dated 8th of May 2001 at page 77.
Yes.
This particular, my lord, finding, it is perverse, and this finding of the competent authority is contradictory to the matters of record, subject to correction of my lords, and based on conjectures and surmises.
Why you are saying contrary to records?
Because, my lord, whatever they will not draw an inference, that has to be substantiated on the basis of the particular depositions vis-a-vis when the departmental proceeding had started. You know, supposing your lordship calls me in a proceeding, lordship issues a charge against me, calls me to attend a proceeding. I am bound to attend the proceeding. Then I have to meet the charges which have your lordship had initiated. Now, on the basis of that, I have to give my evidence, and the vis-a-vis, my lord, the documents which I hold. Now, when after conclusion, when your lordship will be holding
The
passing the order,
contradictions need to be noted.
I am grateful to my lord. Last point, my lord, just kindly give me 5 minutes more, my lord. I appeal to my lords because, my lord, now, my lord, the appellate authority rejected the appeal on 19/8/2002 at page 107 to 109. My lord, I'm sorry, my lord, that I am taking the time of the court.
No,
my lord, because now what I submit to my lords, that, my lord, this order passed by the appellate authority, it suffers from non-application of mind and perverse, and is also cryptic.
All right. Any judgment you are placing?
Yes, my lord, that I am just, if the order of the appellate authority is non-speaking, 2009, Volume 2 SCC, 570, Paragraph 23. এটা জজ সাহেবের দুটো কপি। এই ওকে একটা কপি দে, ও প্রতিটা ইয়েতে
Para 23, yes.
I'm grateful.
That was on the ground of non-reasoning.
Yes, yes.
SN Mukherjee was considered in that.
Millard, I found Millard that, but I leave
So
it to.
this is Rup Singh Negi. Suspicion
This is
howsoever
Rup Singh Negi. Yes.
suspicion howsoever high will not be a substitute to the
Which I told my lords Millard. Now, Millard, now Millard, the next point which I wanted, Millard, this is
inquiry officer কিভাবে proceed করবে?
এনকোয়ারি অফিসারের সম্বন্ধে
Millard, the next point, Millard, which I should, Millard, indicate to my lords,
Yes.
that this respondent petitioner,
Para 14.
he did not commit any listed misconduct. But my lords was saying, Millard, I was trying to get the copy of the particular rules, Millard, of this bank.
Yes.
That I am handing it to my lords, because my lords,
That has been
No, we're carrying the rules as well, my lord. I don't know what my learned senior friend is referring to. 1962 যে rules হলো
ওইটাই দিয়েছি যে আমি তোকে দেখাচ্ছি, এই যে তুই দেখে নে।
no এই পুরোটা রাখার দরকার আছে।
এইটাই
এই যে
কপি কপি জেরক্স করে দিন।
You are relying upon Rule 47.
This is as only up to 2004. এটা কিন্তু post, sir.
পোস্ট, কিন্তু
হ্যাঁ,
এটা আমার
এটা
কাছে
হচ্ছে-
আছে হচ্ছে দিস ইজ দি লাস্ট।
No.
This was amended up to 2004.
This proceedings of 93, my lord, where specifically the charge sheet is of the rules of 1962, which we are carrying if my lord wants to have a look, my lord.
No, that is also same as this.
No, it is not.
This is of
This is of 1962. 1962 rules which were applicable in 1993. This is amended in 2004.
so this was operating.
This was operating. My lord, I can hand up, but
Acha, very good. You check up tally Rule 47.
Yes. I will cross verify with him. And if
You bring out Rule 47.
Hello.
Penalties.
Well,
No, you check it up.
yes,
Tally it.
I'll have to check with my.
এইটা আমি তোকে দিয়ে দিচ্ছি।
Yes, place এটা দাও।
Page 22.
See if it tallies, Mr.
পেনাল্টি চেঞ্জ হবে।
Penalty will be same.
হ্যাঁ
What you are pointing out, Mr. Bhattacharya?
Millard, I wanted to, ভাই তুই ওকে গিয়ে বোঝা, আমি পারবো না, কেন আমি এরকম ভাবে প্র্যাকটিস করতে অভ্যস্ত নয়। Millard, I wanted to show, though Millard, this is my endeavor to before my lords, whatever your lordship Millard takes, Millard, that if I have committed a listed misconduct, then disciplinary proceeding.
What is not a listed misconduct?
Millard, that list
Yes. Rule
has been
47.
given.
What is it? You are showing penalty, Mr. Bhattacharya.
No, I have seen.
মিসকন্ডাক্ট
Yes.
Misconduct is which rule?
Misconduct is কিছু কোনোদিন
তখন তাই
একটু জীবনে কোনোদিন এইভাবে কোনোদিন
36 employees not to say 35 to
not to seek
46.
outside
হ্যাঁ these are the misconduct. মিসকন্ডাক্ট হলে এখানে আলাদা করে ডিফাইন করা কিছু নেই, হয়েছে তো মিসকন্ডাক্ট।
Millard, I am instructed that there is only a scope of conduct, discipline and appeals. There is a scope of conduct, discipline and appeals.
No, the charge was serious misconduct within Rule 47(1).
Yes.
Rule 47(1) is the penalty. এটাই বোঝাইছিল। Without prejudice এখানে যে charge committed an act of serious misconduct within the meaning of 47(1). ওই মিসকন্ডাক্টে কি বলে দিচ্ছে?
Commits breach of the rules of negotiation.
or guilty
পক্ষে
of any
বলছি
other
এটা
act of
হয়নি কিছু।
না আমার বক্তব্য আমি তো যদি হয়ে থাকে তাহলে তো আমি ডিসইন্টারেস্ট
Bishop
এগেইনস্ট দ্য
discipline.
ইন্টারেস্ট অফ দি ব্যাংক তো হয়েছে ওকে
তো একটা করতে পারো।
Yes, anything else, Mr. Bhattacharya?
Milord, my other submission is, Milord, as I told your lordships, Milord, that the order passed by the competent authority is unsustainable because the order passed by the appellate authority suffers
It's a
from
it's a non-application of mind, it is cryptic, you
yes,
said.
yes. Now the points also which I've raised before the appellate authority, that has also not been dealt with.
The points of appeal have not
been dealt with. This has now become, Milord, a law, Milord, which my lords have laid down, that if a particular point is taken before a statutory appeal and the appellate authority should take into consideration, it is not necessary that a detailed finding has to be given. Now, the date of retirement of the respondent writ petitioner is 31/12/2019.
So charge was of 93.
93.
এখনো চলছে সাঁতার।
Rather, Milord, if I may say so, with my greatest of respect, and the orders and the law which is prevailing in the field, this has become an academic issue. Why I say? Because there is no question of any pecuniary loss. I have
punishment is stoppage of 3 increments.
No, and I have suffered also that.
You have already suffered.
Yes, I have suffered the
If you
consequence.
succeed,
Therefore,
you will claim refund of
my
that.
lords will now, Milord, kindly, Milord, your lordship will be ironing out the creases as to whether the proceeding is at all sustainable or the proceeding is not sustainable. It has now become an academic issue before my lords. In my opinion, subject to what falls for my lords.
But then why you have filed this appeal? The punishment
We have
was
not filed
imposed.
appeal. We have not filed appeal.
Basically, whether the order imputing is justified or
not.
Actually,
This is absolutely, Milord.
Since you are
I must not make any
invited,
more comment. Milord, I am just borrowing the expression of my lords.
Yes.
I am borrowing the expression of my lords.
All right, sure. The learned advocates appealing for the respective parties have concluded their argument.
Any other judgment?
And one more judgment is that 2009 volume 2 SCC 570. This is order of disciplinary authority and order of appellate authority that should be based on reasons recorded. Paragraph 23.
23.
2-3. ওটা জোসেফকে দিয়েছিস?
That is Rup Singh Negi which you gave.
2009 এতে দিয়েছিস?
2009 volume 2 SCC 570. This is Rup Singh Negi.
Then
This is what
I'm
you-
sorry.
Okay.
I'll get it.
Before lordship's right.
So since we have applied our mind to the evidence, we are allowing the application for additional evidence. And
Additional, yes.
Yes,
Here I will join one issue. Only one thing I will be joining an issue.
It was within their hands when the matter was being asked.
Yes.
Our clause. We are taking our clause. If court thinks that
Court
it is
thinks,
fair,
court-
Milord, I
we are
just
taking in our clause.
yes.
You forget about Mr. Mumdar and anything. There is our clause also.
Milord, I know, Milord.
Chalo.
Milord, just a second, Milord. Just 41. Milord, your lordship make
ওটা কেটে দাও, কেটে দাও।
Acha, the application under order 41 rule 27 and 27 of the Code of Criminal or Civil Procedure has been prepared. seeking some leave to.
Kindly see this language.
Additional evidence.
I know that my lord is, my lord, I must not make any.
The deposition, Mr. Bhattacharya, what is the wrong if we take it? It
No,
is not
I
a-
say, my lord,
a
at
real-
a stage, why I take this point, I just, this is, the party seeking to produce the additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree was appealed against. Therefore, this was lying with them at the time when the disciplinary proceeding was done.
Go further, Mr. Bhattacharya.
Yes, the appellate authority requires any document to be produced or any witness to be examined to enable it to pronounce judgment. Now, my lord, what is that document? Your lordship is exercising the power of judicial review.
No, Mr. Bhattacharya, as it has gone
It
down
is just
into
like,
the-
my lord, lifting a veil at a stage of an appellate authority. We should not lift
No,
a veil.
you must have seen that this is the deposition of the witnesses.
Yes, yes, to that I have also asked my learned junior that were these documents available.
No, later any.
Some of the depositions are annexed to the paper book, some were not. We collated it in one place and filed it in the application, one after the other, so that there is a chronology of events.
You should have filed a supplementary evidence.
Could have been, but not, we brought it to the court.
We would have final order.
তাই নেই বলে এখনই রেকর্ডিং on consent যদি পৌঁছাতে
না consent.
So you are not giving consent.
No, my lord, I cannot, on behalf of the client, my lord, I cannot give a consent.
It needs
Opposition ready করেও তো ফাইল করেননি, তার মানে তো ডিমড কনসেন্ট। No, we are.
Now, I
you
just,
think
this is my submission. This is my submission so far as, my lord, the provisions of the order 27 is concerned.
No, we understand your provision. But the thing is that this is not a document which was not there in the records before the disciplinary authority.
No, my lord, one
If it had
thing,
been a foreign element, we could have understood.
yes,
Not that
কোন
this
document
document.
কি এরকম ছিল যে যেটা নাকি ডিসিপ্লিনারি প্রসিডিং এ
না না
সময় তোর কাছে ছিল না?
These are all depositions, he says. So we are bringing it in on record since we have already heard and concluded the matter.
না কিছু দেখিয়েছে দেখেন
দেখিয়েছে
দেখলাম তো হ্যাঁ
রিজনটা দিয়ে দেবো আমরা তুমি জাজমেন্ট না এটা মিস্টার ভট্টাচার্যকে ফেরত
আর জাজমেন্ট
সার্ভিস রুলস।
Yes?
No.
Thank you.
Now, I need not place the service rules.
Service rules?
Service rules of the bank.
No, we have given it back.
Yes, your lordship had given it back. I am only, my lord, I am just I am just putting the question to the court that I need not place the service rules of the bank.
For what you are placing?
No, whether, my lord, the proceeding, because your lordship is determining the validity of the proceeding.
Yes, there was
Therefore, for the purpose of adjudicating the validity of the proceeding, whether the rules are required to be produced or not.
Mr. Bhattacharya, we are sitting in judicial review over his lordship's order.
Yes. No, by doing that, by exercising the power of
do you want
judicial.
to mention any rule which we should look into? Do you want us to look into any rule?
No, I just want to indicate before my lords
That the
that the
procedure has not-
particular procedural part of the disciplinary proceeding, whether this has been complied with in toto or not. Because why I say, because I say, why I say this,
Acha, you give.
He has got it.
why I say this, because this is a ego clash.
We shall
Now,
give it
this
back.
matter, my lord, we do not know where it will stop.
ওইটা এটার সাথে
সব তো রিটায়ার করে
একটা আমার সাথে দিয়ে দেবে একটা Yes.
Before lordships rise, item number, I'm sorry to keep you wait, item number 22 and 23, Mr. Talukdar is here, can it be fixed,
It cannot be fixed, Mr. Dhar. It will go up. You know that my brother will not be here. We still
it
kept
would
it
take
in.
hardly 10 minutes.
Come tomorrow. If it is fixed, it is fixed.
Advocate General is leading me in this matter. He appeared earlier.
So you making us afraid.
No, he's not
insubmission
that.
is
The 10 minutes,
Advocate
it will
General
be
is
finished by 10 minutes. I do not know how long it will take.